Good morning, Madam President.
Good morning.
Delighted to join you once again. Listening around the circle, I'm tempted to make another grand speech, but I think that what has been missing from our debate so far is a real conversation about the language in the bill. So I think I'd like to kick that off by asking some questions of the proponent about sections 1 and 2.
Please proceed, Senator Winfield. Prepare yourself.
Thank you very much, Madam President. The first thing I would say is that the first two sections are focused on the notion of banning the open carry of firearms. And my understanding of the bill is that under this new language, if this becomes law, there will be no open carry allowed anywhere except for your own property and at a firearm training facility or a firing range. And that the expansion now includes long guns and not just pistols and revolvers. I'd just like to confirm that I got that completely right. Just kick it off. Through you, Madam President.
Thank you, Senator Winfield.
Thank you, Madam President. That would be correct, with the exception that, as I'm sure the Senator knows, there are persons in certain roles that are an exception to that as well, parole officers, et cetera, that are a little bit further down in that section.
Senator Sampson.
Thank you very much, Madam President. Yes, we're certainly going to talk about the folks that have exceptions and the many people that I think should have exceptions that do not. But I guess the first thing I would ask is, what is the purpose of this section? What do we hope to achieve by banning the activity of open carrying a firearm?
Senator Winfield.
I'm not sure how to answer what we hope to achieve by banning open carry other than banning open carry, Madam President.
Senator Sampson.
Well, thank you very much, Madam President. I appreciate that answer, but we're here debating the nature of the policy that's before us, and I'm certain that the folks that are going to support it are going to do so because they believe that the policy is going to be an improvement in Connecticut and it's going to alter the future direction of crime, violence. It's been advertised. The governor I quoted earlier said that this is common sense gun reform. Can you point to an example of how banning the activity of open carrying a firearm is going to prevent a future crime? Through you, Madam President.
Senator Winfield.
Madam President, I can't divine the future, and I don't speak for the governor. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. How about the past? Can the good chairman of the Judiciary Committee point to an example of where someone open carrying a firearm in the past resulted in a violent crime or the death of someone?
Senator Winfield.
Madam President, perhaps had I attempted to answer that question with some foreknowledge, maybe, I don't know, but that was not how I came in here, so no.
Senator Sampson.
Thank you very much, Madam President. I mean no disrespect, but if we're going to kick off our bill, this is the very first two sections of the bill. This is the premier item that is in this policy, which we're being told is going to have all of these tremendous benefits. I heard a number of my colleagues speak around the circle about how this is going to change the direction and make Connecticut a safer place. And I argued in my opening that crime is the issue and not victimless crimes, because after all, open carrying of a firearm, whether it's a handgun or a rifle, is not causing anyone any harm. If it was, I could see the point of this section, but I'm trying to understand. I'm looking through the statistics from the case statistics from the Office of Legislative Research, and there's some fascinating information in here. I would encourage anyone who's really interested in understanding about the real levels of gun violence in our state to take a look at this. And what's very interesting about it is looking at the number of individual types of crimes and the prosecution rate, how many are dismissed, how many are nollied. And I'll just, without going off too far on a tangent, I'll just say that many of my colleagues pointed to the fact that we are failing in the criminal justice department. You know, a lot of my colleagues argue that crime is down in Connecticut. And I would say that if we're all relying on the same statistics. So if you look at the statistics, you can certainly make that claim. But the fact of the matter is, it's not that crime is down, it's the prosecution of crime is down. And it's very easy to look at any one of these charts. Illegally transferring or purchasing a pistol or a revolver, you can look at this and say there were 103 total cases in 2022, but 90 of them were nollied, 6 of them were dismissed, and only 7 of them ended up in a guilty verdict. And it was same more or less for the previous years. And there are many other crimes like this. It doesn't look like there are a tremendous number of, let alone charges, in many of the things that could be associated with the bill before us, let alone prosecutions. There is no section in here that says violent crimes resulting from open carrying, because that doesn't happen. A violent crime can certainly occur from someone concealed carrying, open carrying, or carrying an illegal firearm. All of those things are possible, but the mere fact of open carrying, I don't think, is a crime in and of itself, and I'm concerned that we're about to make it one without good reason. So I'm leaning on the majority here to tell me what the reason is so that it can be justified. I would add that I have concerns that we're reaching quite far into people's lives here. You know, I think some folks have a vision of just random people who are putting a gun on their hip and you know, going into the local Dunkin' Donuts or walking around Walmart, etc. And while that might be a factor here, there are lots of other things that this bill touches. In fact, my reading of this bill says that if I want to go visit a friend of mine who lives out in Plymouth, he owns a couple of acres, and we like to, you know, plink, you know, cans with our .22 rifles, you know, far away from anyone, perfectly lawfully, he's got permission from the town to do so and so forth, that this bill would prevent me from being able to be there with a firearm in my possession, because I would be open carrying and not on my own property and not at a firing range. Let me ask another question through you, Madam President. We didn't have any data on crimes in the past or what type of crime might be prevented. How about, do we know how often criminals open carry firearms? Through you, Madam President.
Senator Winfield.
Through you, Madam President, I don't know that. And listen, people approach this with various reasons for feeling as though one section matters to them or not. This is a question of public policy. We heard earlier about law enforcement and the impact it can have on law enforcement to have to deal with those with open carry, and whether or not someone is acting in a manner that is legal or not, and whether they have the right to ask for a permit. That's all been part of the conversations that the good senator has been a part of on a Judiciary Committee. There are plenty of reasons why people come to this. The box that we are trying to get the answer out of, I don't have the answer for that, but there are plenty of reasons why people come here, and it's a policy decision based on those many years of conversation we've had, and there are good reasons to do it, one of which is the impact on law enforcement, the impact on people who might be concerned about someone open carrying. Maybe they are not doing anything wrong, but the concern that they have, and then expressing that to law enforcement and what happens at that interaction. Through you, Madam President.
Thank you, Senator Sampson.
And thank you, Madam President. I appreciate those comments, and I honestly don't mean to put the chairman in a difficult position by asking him complicated questions. I don't think that these questions are answerable is really the issue. He just noted that maybe they're not doing something wrong, and that's my feeling also, which is that in Connecticut, open carry has been lawful since the beginning. And it might surprise some folks to learn that 45 states open carry is lawful. We would be really stepping out of the realm of what I think most other states do as far as public policy to do this. And when we're going to go ahead and set an example and create a new public policy, which is going to impact a little over 300,000 lawful, permitted, background-checked gun owners in this state, I think we ought to think twice about that. Statistics will tell us that people that have pistol permits have far lower incidences of and criminal records than the average person. So it seems odd to me that we would take a victimless crime, that there is no evidence results in criminal activity or danger or gun violence, and suddenly make that illegal. And to stretch that coverage of this policy so far that you're actually prohibiting people from being able to carry a firearm where it's welcome, like on a friend's or a neighbor's property. I just find it surprising. Do you, well, let me ask you a question about those 300,000 plus permit holders in Connecticut. I think that's 326,000 actually, who've gone through the process of being fingerprinted, background checked, the whole 9 yards, have been checked out completely, and have been authorized to possess a firearm and to carry one, and to carry it open in Connecticut. And that's been the law since the beginning, as I mentioned. How, if this becomes law and the governor signs this bill and it's effective, how are the 326,000, give or take, pistol permit holders in the state going to be aware that open carrying is no longer lawful? Through you, Madam President.
Senator Winfield.
I guess I would ask back the question, is the senator asking the mechanism by which they would,
Senator Sampson.
sure, I'm sorry.
Yeah, thank you, Madam President. Yes, I want to understand exactly how we're going to let them know, because right now, if I'm open carrying, it's not a crime. But assuming this bill passes, the governor signs it, it's the law. A few days from now, there are going to be people all across Connecticut who are going to be committing a crime, and I doubt they're going to know it, because as much as the news media is going to cover this bill, I don't know that it's going to reach every soul in Connecticut, and certainly not in a few days. And we are going to be making those folks guilty of a Class B misdemeanor for a first offense and a Class A misdemeanor for any subsequent offense.
Senator Winfield.
Not to quibble about time, but that section of the bill doesn't go into effect for a couple of months. But also, as I've seen, there will be a lot of news coverage. My understanding of the community that we're talking about, they're very involved in this conversation right now. Word is spreading, but there's not, if the question is does the bill have a mechanism built into it to do that? The answer is no.
Senator Sampson.
Thank you, Madam President. Well, that's a concern of mine, that we are going to take a victimless crime that has no real connection with danger or violence or mayhem, and we are going to begin turning otherwise law-abiding people who I would say are certainly value their Second Amendment right so much that they went through the process and were willing to be background checked and pay for a firearms training course and everything else. And we are going to make those folks guilty of a misdemeanor, which I believe would deprive them of their right to even have a pistol permit in the future. I think it's a lot. And I think it's a lot also to suggest that somehow it's suddenly going to become against the law for me or anyone else to go and, practice some shooting on a neighbor's property. It seems really out of the realm of good public policy, or something that is necessary to ensure the safety of Connecticut citizens. The fact of the matter is that people who shoot recreationally like that, spend time in their neighbors' backyards shooting bottles and cans, those people are ultimately one of the best preventions we have for violent crime. Their mere existence in our society prevents crime. I mentioned when I started earlier today that I was going to go through each section and remind everyone to test each part of this bill against several questions. I hope we remember what they were, but I mean, the first one was, will it work? I don't see how enforcing such a law is going to work based on the notion that we couldn't come up with a single situation that has occurred where we would have stopped something, nor can we even predict one. I also talked about the constitutionality, and I think that, one thing that is lacking from this conversation is that we are bound by our oaths of office. I mentioned that very briefly when I started. We are not free to make whatever policy we feel like, especially when we don't have good reasons to make that policy and we have nothing to back it on. And thank heavens, people smarter than us in the past, laid a groundwork to prevent us from making policy outside our realm. And we still have the court system to remind us of that when we go too far. And there's been a number of challenges over the years to various gun control legislation. And the most recent one was the case involving Bruin versus the state of New York in 2022. That was a very interesting case. And I want to just talk about it for a quick second because it is so relevant to the legislation that is before us. And it's an expansion of my charge at the beginning of this, that we have to test these proposals. Will they work? Do they make sense? Do they have disparate impact? I'm going to return to the notion of disparate impact on open carry in a moment. In fact, let me do that first. Let me just say that I'm concerned that when you start to apply a law like this, especially for something that has not been illegal in the past and is likely to surprise as many of those folks open carrying as the people around them, that it's now a law, I think you're going to have more interactions with law enforcement. And I think there is a very, very real chance that you may be creating an incident out of such a situation, particularly in an inner city environment. I'm concerned because I want to make sure that every person is able to exercise their full and 100% rights as American citizens. And I don't think this bill honors that right. And that brings me back to the Bruin case, which clarified the standard in Second Amendment cases. And according to that Supreme Court decision, it says the government must affirmatively prove that any firearms regulation that it passed is part of the historical tradition of firearm regulation by presenting analogous laws from the constitutionally relevant era. And what that means basically is if you're going to pass a gun control law, you have to compare it to something similar that was actually in effect at the time that that constitutional element was passed. So our U.S. Constitution, the Bill of Rights, 1791 actually, for the Second Amendment. So in 1791, was there any equivalent policy that prevented anyone from open carrying a firearm? Through you, Madam President.
Senator Winfield.
Madam President, I don't know how to answer that question because not everyone I don't know. I mean, in 1791, not everyone had the right to carry a gun. So those people couldn't open carry.
Mm-hmm. Senator Sampson.
Yeah, no, I don't disagree. And there's a lot of things that have changed over the years, but I'm concerned about this particular standard, which has been upheld by the Supreme Court. It says when it comes to interpreting, and I'm quoting them, when it comes to interpreting the Constitution, not all history is created equal. It says constitutional rights in particular are enshrined with the scope they were understood to have when the people adopted them. So when the Second Amendment was drafted, and it's been reaffirmed to be an individual right over and over again, including in Bruin, it's an individual right, certainly in our Connecticut state constitution. Was there any situation where someone would have been said that they can conceal carry but not open carry as a licensed permit holder? And the answer is no. I'm not going to ask the question again. I already asked it. The fact of the matter is that it doesn't. There is no equivalent standard. And I believe that this particular proposal to ban the open carrying of firearms will fail at constitutional tests based on that. And I'll just stop for a moment and make a plea to the Supreme Court of the United States to please save us here in Connecticut. Because I've been here for 10 years and I've watched gun control bill after gun control bill that flies in the face of our constitutional protections being passed into law. And I've seen challenges on the state level fail, but we need the Supreme Court of the United States to actually reach down and pick up these cases and adjudicate these things once and for all. I guess I'll move on to Section 3, which is about ghost guns. But before I do, I'm reminded that I have some amendments here and another question or two on the open carry section of the bill that I really do need to address. And that is that in line 17 and 18, there's a statement that says neither a fleeting glimpse of a firearm nor an imprint of a firearm through such person's clothing shall constitute a violation of this subdivision. But there is no definition in the bill for fleeting, fleeting glimpse, nor is there a definition for imprint. And I think this is critically important because police officers are going to end up in situations where they have got to interact with someone that may or may not be open carrying based on these terms. And this is the difference between telling somebody who may be a lawful gun owner whether they are guilty of a misdemeanor or not. So I think it's very important that we understand what exactly is meant by the notion of fleeting glimpse. And I'm wondering if the good chairman can share a response with me on that.
Senator Winfield.
Yes, thank you, Madam President. As we've discussed over and over in this chamber, and I'm sure in the other chamber, when a bill does not define the words in the bill for the purposes of the bill, we then refer back to the dictionary. In this case, when we're talking about a fleeting glance, I mean it would last for a very short period of time, as I'm sure that the senator recognizes, and an imprint would be what would appear to be an outline or imprint of the gun. And I'm assuming we're talking about as it relates to articles of clothing, so in that article of clothing, through you, Madam President.
Senator Sampson.
Thank you, Madam President. I can understand the reliance on the dictionary, but that's not going to help someone who is being accused of a crime. And I think it's very, very important that we clarify exactly what these terms mean. And the notion of fleeting glimpse, the one thing that strikes me about that is that means that if somebody, a police officer or a witness, says that they saw something as a fleeting glimpse, but maybe it was going on for a long time, or maybe someone was watching someone for a long time, but then they only had a fleeting glimpse of the firearm being exposed. Those are two entirely different situations, but even that's not clear in the bill. And then the other thing is with regard to the imprint of a firearm. Would the imprint of part of a firearm, like for instance, if someone was wearing an in-waistband holster and only part of the stock or the grip of the firearm was exposed, would that qualify as an imprint, or could somebody find themselves in trouble for open carrying based on that? Through you, Madam President.
Senator Winfield.
Yes, thank you, Madam President. I don't know that I understand the question because in the question about the imprint, there was an explanation of part of the item being exposed. That's not an imprint.
Senator Sampson.
Thank you very much, Madam President. Well, I'd like some clarification on whether or not the entire firearm needs to be exposed for open carrying to be an issue. I'd like to know if someone has a fully holstered firearm, but it's in plain view, but you can't see the firearm at all. Does that count as open carrying? And I would like to know if someone has a firearm underneath their clothing, but you can clearly see that as a firearm, whether that is an imprint or because it's so obvious it actually becomes open carry. And I'm not asking these questions to be difficult. It's not my choice that we are having this debate at 12:35 p.m. on a Friday night. That was done on purpose to prevent us in the minority from having an effective ability to filibuster this bill and prevent it from passage. You know, that was the choice of the majority to bring the bill out and why we're here so late at night. And the questions I'm asking are very important. There will be people in courts of law as a result of this becoming law, and they deserve to have a clarity in the policy. So respectfully, I really want answers to these questions that can help. And if there aren't clear questions, I have a couple of amendments to clarify the notion of fleeting and imprint. Through you, Madam President.
Senator Winfield.
Thank you, Madam President. I will just say that quite a few questions were thrown in there. I don't remember all the questions, so we're going to have to go through them hopefully one by one, but if you want to throw them all out, I'll catch them as I catch them. And also, I am making, I don't think I've suggested this, but if I did, I didn't mean to. I've made no commentary on the senator's ability nor right to ask questions. I'm here with you. As you know, I've had a lot of, I've had more long debates than anybody. So I'm here with you. If we leave at 2, 3, 4, 5, 6, 7, 8, 9, 10, it's fine. Your questions.
Yeah, let's try them one at a time. Senator Sampson.
Thank you very much, Madam President, and I appreciate that. And I meant no disrespect to the chairman. He and I have always had a very fair relationship, and I'd like to continue that. Let's start with the one about someone carrying a firearm in a holster, but the firearm itself is not actually visible. Would that fall under the category of open carry in this bill? Through you.
Senator Winfield.
I'm going to ask for, through you, Madam President, I'm going to ask for a little more clarity. So the firearm is on the person in a holster in a way that one cannot see the firearm, they can just see the structure of the holster.
Senator Sampson.
Thank you, Madam President. Yes, there are a number of holsters that actually have a cover that flips over and can be buttoned. Or you could have a situation, and if these are different answers, please share with me. You could also have a situation where maybe the bottom of the holster is visible into the open, but they have a shirt that's untucked over half of it. Would either of those situations result in someone being guilty of a crime under the bill before us?
Senator Winfield.
What I would say, thank you, Madam President, through you, Madam President. What I would say is, as the bill lays out, what has to happen is there has to be the person who is knowingly carrying the firearm and intends to display the firearm. So I think it is conditional, and as I understand the circumstance, I'm not sure I have enough to actually answer that question, but it seems like this individual may not be intending to do what would trigger here, but I think to be 100% sure, as I'm sure the good senator knows, we have to know all of the pieces of the particular set of circumstances to answer that.
Senator Sampson.
Yeah, thank you, Madam President. I appreciate that. And I'm not asking you to determine guilt in a court of law. I'm merely trying to establish some level of legislative intent to guide the courts if they are ever in a situation of having to interpret the bill before us. Again, the language does not identify definitions for the terms fleeting glimpse or for imprint of a firearm, and even the notion, and I'm sorry for repeating that word so many times, the idea that open carrying of a firearm may or may not include the actual firearm, but a holster, I think is an important question that we should tackle today. If there is more specific information that I would need to provide, I can certainly do that. And I don't want to belabor this point. I have a lot of things to get to. I'm not trying to delay this at all. Through you, Madam President.
Senator Winfield.
Just for clarification, the holster is not a firearm. What is referred to in the bill is the firearm itself.
Senator Sampson.
Thank you, Madam President. So based on that, I would gather that someone who has a holster that is in plain view, but the firearm itself is not in plain view, would not be guilty of a crime under the bill before us. Is that correct?
Senator Winfield.
Madam President, while I would suggest that some people might want it to be, the letter of what is in front of us suggests that if the firearm itself is not in plain view, the issues that one would think would be covered here would not be covered. Through you, Madam President.
Senator Sampson.
Thank you, Madam President, and I appreciate that answer, and not to belabor it, and certainly not to put the good chairman on the spot again, but how about a situation where the holster is covering the majority of the firearm, but some of it may be visible? Through you.
Senator Winfield.
Thank you, Madam President. In that situation, it depends on quite a bit, right? The intention and all of the things that are the trigger, but as the firearm, and in this case, I believe that the firearm is any piece of the firearm. Potentially, depending on the set of facts there, you could be in a situation where you are, if it's not a fleeting glance, a case of open carrying.
Thank you very much. We lost our...
Senator Sampson.
Thank you very much, Mr. President. We timed the changeover poorly, and I apologize for that. I appreciate those answers, and I guess I'll leave it there for now, other than to suggest that we really, when we write policy like this, which is going to have a real-world impact, real people are going to be affected by what we do here today. I know it's real easy to say, yes, we need to pass this policy and we need to, ensure the safety of kids and everything else, and we all believe that. We all believe that. But you have to remember that when we put words on paper and we take votes here, that goes out into the real world and there is an effect there. And we should be very clear about what that effect is. And when we are not, we can cause real problems. And as I mentioned before, one of my grave concerns about these first two sections of this bill are situations and circumstances where people who were never in contact with law enforcement before, because this was not a crime, are now going to end up interacting with law enforcement. And I can just see a well-intentioned officer and a decent person coming together at a Dunkin' Donuts, line or something like that, and arguing over whether or not someone's open carrying as a result of whether or not some of their firearms been exposed, even temporarily. I think that is more likely to cause a problem than to have recognized that we're talking about something that should not be a crime at all, because there is no victim. Out west, it's customary for people to open carry, much more than in Connecticut. And I recognize that's part of our culture here, and one of the reasons why I think this made it into this bill is that people are not as accustomed to see people open carrying a firearm. But if you travel around the country, there are some places where it's very common. You go to the bank in Arizona, the other four people in line with you are going to have a holstered firearm on their hip. They don't have many bank robberies in Arizona, and maybe that's the reason. I'm going to offer an amendment, Mr. President, because I do think it's very, very important that we define the two terms fleeting glimpse and imprint. The first one is LCO 9546. This is a very simple amendment. I ask that the clerk call it, and I can summarize.
Please proceed.
LCO number 9546, Senate Amendment F.
Senator Sampson.
Thank you very much, Mr. President. As I said, very simple amendment. This creates a definition for clarity's sake for both a officer in the field and for law-abiding gun owners to recognize what a fleeting glimpse actually entails. I have crafted an amendment that says a fleeting glimpse means any display of a holstered firearm for any period of time during which the person carrying such firearm does not know such firearm is being displayed or intend to display such firearm. I move adoption. I'd like a roll call vote.
Thank you. The question is on adoption. Would you remark further? Would you remark further? Senator Winfield.
Yes, thank you, Mr. President. I rise in opposition to the amendment being offered.
Thank you. Would you remark further? Seeing no other remarks, Mr. Clerk, please, I'll turn the machine on. The machine is on. Please, senators vote.
Immediate roll call vote has been ordered in the Senate. Immediate roll call vote has been ordered in the Senate. Senate Amendment F, House Bill 6667. Total number voted 36, total voting yea 12, total voting nay 24, absent not voting 0.
Amendment fails. Senator Sampson.
Thank you, Madam President. As I mentioned, I have a similar amendment to define the word imprint. This is a very straightforward amendment, too. It's LCO 9544. Again, I asked the clerk if he would call that amendment, and I be given leave of the chamber to summarize.
Yes, Mr. Clerk.
LCO number 9544, Senate Amendment G.
Senator Sampson.
Thank you, Madam President. A very short one-sentence amendment also. This defines imprint. It says, for purposes of this subdivision, imprint of a firearm means any bulging or outline of a firearm, however obvious to any person through any clothing or other garment covering such firearm. I move adoption. I'd like a roll call vote.
The question is on adoption. We will have a roll call vote. Please proceed to summarize.
I don't need to summarize, Madam President. It speaks for itself.
Yes, it does. Yes, it does. Will you remark further on the amendment? Will you remark further on the amendment? If not, I will open the voting machine as a roll call has been requested.
Immediate roll call vote has been ordered in the Senate.
What's the tally?
Senate Amendment G, House Bill 6667. Total number voting 36, total voting yea 12, total voting nay 24, absent not voting 0.
Amendment fails. Senator Sampson.
Thank you very much, Madam President. I'm a little disappointed those amendments failed. I'm not surprised this is the way it's gone in this chamber recently, which is that it seems that any amendment, no matter how small or clearly necessary, tends to fail on a party line vote. And I'm hopeful that we can, before we get done with this, that we'll get to a point where we can find some common ground on some things. I had mentioned earlier my concern about people not being able to open carry a firearm in other places other than their home, because there are quite a few places I can think of where it's not out of the ordinary and we would be restricting behavior that's not been restricted in the past. I also would note that there are a number of people that work in different professions that don't fall under the categories that are listed in, I think it's sections 1 and 2 of the bill about who is able to continue to open carry. I'm thinking of bail bondsmen, certain types of private investigators, maybe. I know we have federal marshals, but I don't know about judicial marshals, for example. There are some concerns about how this is going to impact people, and I don't know that we've gotten the proper testimony or feedback to recognize that. Someone actually casually mentioned to me the idea of a 21-gun salute at a funeral. If you don't have folks that fall into this category participating, they would effectively open carry a long gun. Would we be prohibiting somebody from having a 21-gun salute at a funeral? Through you, Madam President.
Senator Winfield.
Thank you, Madam President. And through you, Madam President, that would not be the intention. And I can't remember because there were several conversations yesterday or the day before, I don't remember at this point, about the issue of bail bondsmen, people transporting money between banks, and a whole list of folks who there's a concern about them not being able to do what they would be doing. And the reason why I brought this up as it relates to Senator Sampson, we were talking about an amendment that I actually was going to give him. So despite the notion that we don't ever respond to amendments, and attached to that was a potential fix or change to the bill that is not on the bill itself that would deal with that issue, through you, Madam President.
Senator Sampson.
Thank you, Madam President, and I appreciate those comments, certainly. But I'll just leave it out there that this is yet another question that I don't think is sufficiently resolved. And when we cast our votes today, that will effectively be the end of discussion and debate. This bill has already passed through the House of Representatives, and I imagine it will be transmitted as fast as lightning over to the governor for a signature. And yet, there are unanswered questions, and I'm still on the first 4 or 5 pages of a 92-page bill. And I think we've uncovered a number of concerns, and all for the sake of a victimless crime that we cannot point to as the source of any violence. It surprises me. My probably top priority in this section of the bill really is the idea of being able to open carry on someone else's property. It seems to me that if you are lawfully able to open carry on your own property, and I'm thankful that we respect that at least, because sometimes in here I have my doubts about respect for individual property rights. I also think that your neighbor or your friend or a business or someone else who owns their property also ought to dictate the terms. And we've seen cases where people deny folks the ability to carry a firearm on their property. But here we're also suggesting that we can't even allow someone to determine that someone can carry a firearm, at least openly, on their property. And as I mentioned, it's a wholly, almost New England American thing to do, to go plinking in somebody's backyard, assuming, they live with enough property and so forth to do so. And as a result, I'm going to offer an amendment, again, through you, Madam President. This one is LCO 9549, and I ask the clerk to please call this amendment, and I'd be given the opportunity to summarize it.
Mr. Clerk.
95, LCO number 9549, Senate Amendment H.
Senator Sampson.
Thank you, Madam President. Another very short amendment. This one, the operative language basically says that folks would be able to open carry within a dwelling owned or leased by any other person, or land leased or owned by any other person, or within the place of business of any other person with such other person's permission. And as I said, I believe that's only right, that people should be able to dictate what activity is allowed on their own property. I move adoption, and I'd ask for a roll call vote.
We will have a roll call vote. Would anyone like to remark on the amendment? Will you remark on the amendment? If not, I will open the voting machine, Mr. Clerk.
Immediate roll call vote has been ordered in the Senate. We're voting on Senate Amendment H. Senate Amendment H, House Bill 6667. Total number voting 36, total voting 812, total voting 824, absent not voting 0.
Amendment fails. Senator Sampson.
Thank you very much, Madam President. I was hopeful we would be very much in favor of rapid-fire amendments. Not to be ironic
Poorly chosen words.
or
on my
yes,
part.
exactly, or a very poorly worded pun. So I do have another amendment on this section, and this one has to do with self-defense. early on in the section about open carry, there is a sentence that says if a person displays a firearm temporarily while engaged in self-defense or other conduct that is otherwise lawful, such display shall not constitute a violation of this subdivision. And there's a lot of questions I have about this particular sentence. But the one thing I thought was important is that we really do clarify the idea of self-defense, because it says while engaged in self-defense. And I don't know if that would mean that someone would actually ultimately have to prove they were acting in self-defense to not be guilty of the crime of open carrying a firearm. So I have an amendment, once again, through you, Madam President. This one is LCO 9543. I asked the clerk if he could call this amendment, and I'd be allowed to summarize.
Mr. Clerk.
LCO number 9543, Senate Amendment I.
Senator Sampson.
Thank you, Madam President. This amendment simply makes it clear that the person who is open carrying will not be guilty of a violation of this part of the bill if they believes it is necessary for self-defense. That's the language that we are adding, and I move adoption, and I'd like a roll call vote.
Thank you. Will you remark further on the amendment? If Senator Winfield.
Yes, Madam President, I rise in opposition to the amendment. I don't actually believe that it clarifies, making it about the belief that they're operating in self-defense. That there are many ways in which people believe things that aren't actually what's going on. I think it needs to be that the person was operating in self-defense. I recognize why there's a difference of opinion there, but I rise in opposition to you, Madam President.
Thank you. Will you remark further on the amendment? If not, I've opened the voting machine, Mr. Clerk.
Immediate roll call vote has been ordered in the Senate. Vote on Senate Amendment I.
Amendment I, total voting 36, yay, 12, total nay 24, absent 0.
Thank you very much, Madam President. I just have a few more comments on the first couple of sections regarding the ban on the open carrying of firearms, and I'm certain folks are ready to move on, and so am I. But I just wanted to bring up a couple of more points. One of them is I was thinking as we were having this conversation about the imprint and the displaying and you know, what a fleeting glimpse might be, just how much of an impact this might be having on people's attire, particularly women. Today, more than ever, there are lots of female concealed carry and open carry firearm owners. And I think that in some respects, this particular proposal might be somewhat limiting to them and their freedom to address and exercise the Second Amendment the way that they have in the past. And I don't know if that's something we really wanted to accomplish here. And there was something else that was brought to my attention on the subject of open carry, which is that there have been municipalities in Connecticut over the years that have actually restricted concealed carry. They passed a municipal ordinance says you can no longer conceal carry in our town, so you were forced effectively to open carry. And I'm told, I don't know how 100% accurate this is, but I was told earlier today that the city of Ansonia actually still has that municipal ordinance that says you cannot concealed carry. So effectively, if that's true, we would be preventing folks that live in the town of Ansonia from being able to exercise their Second Amendment altogether. Between the municipal ordinance preventing concealed carry and this policy passing and preventing open carry, what do people do in a case like that? And I had considered doing an amendment regarding preemption. I know we've had it before the Judiciary Committee a number of times. It's just something I never got around to. But it is a question that should be answered, and I'm hopeful that maybe next year in the Judiciary Committee that it's something that we can address, because we cannot, no matter whether this becomes law or not, we cannot completely deny someone's right to carry a firearm in Connecticut. And I think folks will be glad to hear that I'm going to actually move on to Section 3 of the bill, which is the section that has to do with what are defined as ghost guns. I remember that when we had the debate on this in 2019, when the very first ghost guns bill was passed, I remember asking whether or not a ghost gun was an ethereal gun or it was a gun that belonged to a ethereal being. And I know that's not particularly funny, but either is the term ghost guns. That's a political term, and I think it's misused because it captures many different things, and this bill captures many different things under this category. And I would say there's two main sections of firearms or main categories that are captured by the term ghost guns. First off are guns that were produced without a serial number ever throughout their manufacturer. And those are captured by this bill. And so are firearms that are being manufactured now, often by people that are enthusiasts that like to build custom firearms. They'll purchase different parts of a firearm that are at different states of manufacture, and they'll finish it off themselves in a custom way. And we do provide a process in Connecticut for someone to obtain a firearm to do that. And then, of course, there's a whole other category of people that actually do things for nefarious purposes. They remove the serial number from a firearm, or they use a 3D printer to print a firearm for the use in a crime or otherwise. These are very different categories. I note that the bill affects firearms only manufactured after a date, December 16th, 1968. I'd ask the chairman if he can answer why we've chosen that particular date. Through you, Madam President.
Senator Winfield.
Madam Chair, if I remember that date from conversations we've had in the past, conversation on ghost guns. But if the good senator could orient me to where he is, that would be helpful too.
Senator Sampson.
Through you, Madam President, that date appears on line 284 of Section 3.
Senator Winfield.
Madam President, I am unfortunately drawing a blank at this moment. I do remember having this conversation, but I'm drawing a blank at this moment on the date. Sorry.
Senator Sampson.
Thank you, Madam President. That's fine. I'm not certain of the date either. I presume that it has something to do with the date that certain manufacturers may have begun serializing firearms, but I don't know for a fact. I was hoping we could narrow that down if that was truly the case, because I do have a concern about the great number of firearms that were produced in the 50s and 60s in particular that did not come with firearms. You could, for a very long period of time in Connecticut, go into a department store, a Kmart, a Sears, and purchase a .22 rifle or a shotgun with no serial number whatsoever. It was perfectly lawful to do so. And in fact, I think you could do it at a younger age than is currently allowed by law. You might not even have had to have any type of permit or license or long gun certificate to do so. And ironically, I think that we live in a much more dangerous time with a lot more crime today, and I wonder if that has anything to do with that. And I am at least pleased that that date is as far back as it is, but also more than likely captures only firearms that were manufactured with serial numbers. But I would be hopeful that we actually did a good job of defining a good cutoff. So I will say that I have a Civil War musket at home that was left to me by my family in the past and handed down to me, and that thankfully is exempt And I understand the chairman has some more information for me, so I will yield to him. Through you, Madam President.
Senator Winfield.
Yes, Madam President. When you don't remember, you look it up. So, Madam President, December 16th, 1968 was the effective date of the Federal Gun Control Act of 1968.
Senator Sampson.
Thank you very much, Madam President. Yes, and I believe that Federal Gun Control Act probably required the serialization of firearms, and therefore is a relatively decent date to use for this section. And I'm thankful because this bill could have been drafted in a lot of ways, and I don't care for the policy that's in here, but it could easily have captured many, many more people. I myself own a .22 rifle that was manufactured in the 1950s. It was a gun that was passed down to me by my father, and it does not have a serial number on it. And but I mean, it's a modest wood stock .22 rifle and all, but nonetheless, I would hate to discover that I am guilty of a crime as a result of possessing a firearm for decades, effectively, and my dad before me possessing it. I noted in the bill that it says that this information, if you have a firearm without a serial number, you have to declare it by January 1st of 2024, or you will be in violation of this bill. And I have several concerns about that. First off, I don't like the idea of registering firearms. I don't want to give any, ranting, remarks about history and all the times that various regimes, authoritarian communist regimes, have required the registration of firearms, and it's always ended up with the extermination of the people in those countries. But I will leave it there. That's what has happened, and that's what people who own firearms are concerned about, which is that registration of a firearm means that the state itself has knowledge of every firearm and who owns it. And it's only a matter of the will of the state to just decide based on a policy, maybe well-intentioned, maybe not, and maybe well thought out or very vaguely written, that could result in the confiscation of those firearms. And it's well known for people that are concerned about the Second Amendment that registration leads to confiscation. And so I don't like to see any type of registration in a bill, especially when, as we have discussed, this is yet another victimless crime. No one is being harmed by the fact that someone may have an old firearm that was manufactured without a serial number, or was manufactured by an enthusiast. As long as the person that is in possession of it is in possession because they are a lawful owner of that firearm and they're not using it for any nefarious criminal purpose, why should it be a crime to simply possess something? I really do believe that the folks that are proponents of this bill have really stepped outside the realm of what is really like thoughtful policy by engaging in creating crimes out of things that actually don't harm anyone. Each one of these items, and we'll go through them, they're all victimless. Who cares? Yes, we should have criminal penalties for things that actually harm people. The debate earlier was all about the fact that our state has become more and more lawless over time. I listed some of those things in my opening remarks about the risk reduction credit program and the reversal of police chases and consent searches, and we're erasing criminal records now. We had a big dust up about commutations. There's the undermining of law enforcement, not just the police accountability bill, but the rhetoric that we're hearing from some across this country about police. It does not help. And I'm not in a position to take a side one way or the other about police always being correct or not. I would never do that. But the fact of the matter is we cannot maintain law and order in our society unless we have the rule of law, and if we put laws on the books, they have to be enforced. I really wish I had the time to go through this OLR report I mentioned earlier. It's worth a read. You'll be surprised at just how rarely we end up prosecuting folks for significant crimes. And I don't know what the facts are, and I don't want to cast any aspersions on the people that are prosecuting these crimes or the judges involved and so forth, but it begs a lot of questions. I will just leave it there. I don't know that we are apprehending enough people that are engaging in true criminal activity these days, and I don't know that we are actually prosecuting them when they are. But I also believe very strongly that people are innocent until proven guilty, and I certainly believe that people who have not harmed anyone and are not guilty of a crime that would actually cause physical injury to someone, like open carrying or even possessing a so-called ghost gun, should be guilty of anything, unless they are using it for negative or other unlawful purposes. This bill, as I mentioned, records the registration of these firearms by necessity, and it says that that registration will be shared with the Department of Corrections, with the Department of Mental Health, I think probation office was listed here too. I don't have it right in front of me. But there were a number of government entities that would have access to this information. It's very big brother to be sharing the information about all of the privately owned firearms in the state of Connecticut. These are the citizens that we represent. Why are we sharing this information? You know, we had a bill in this chamber about a week ago where it was proposed and passed out of this chamber, and I know it was debated in the House as well today. It probably passed there. It's going to become the law that we are going to protect the home addresses of all state employees and make them exempt from the Freedom of Information Act. It's interesting that the state itself would be granting itself such generous protections for privacy, and yet here we are, somebody who's not guilty of any actual crime that has caused any danger or imminent danger to another person would end up being on a list or face a very significant penalty in the law. I looked up the records and I found out that since July of 2019, so we're talking several years now, there have been only 56 ghost guns. I don't know if they're actually called that at some point when they are registered and someone obtains a registration number for them. But this begs the question, do criminals actually register their firearms? I mean, I'm trying to figure out the right words to phrase this, but the problem with many of these laws is that we are effectively turning people into criminals in one respect, but we are also suggesting that criminals are going to engage in the same kind of behavior that law-abiding citizens would. So when you create a law that says that you must go through this process if you are going to manufacture a firearm and go through the trouble of asking the Department of Public Safety to get a serial number and provide them information and so forth and go through this process, yes, law-abiding citizens will do this process. It's a nuisance, it's aggravation, it's unnecessary, but yet they will do it. And they will do it because they are people that obey the law. But the very people that would not obey the law and would engage in criminal behavior or would steal a firearm and remove the serial number from it or try and obtain a partially constructed firearm to be used in a crime, they're not going to do any of these things. They're just not going to. So it seems fruitless to me to try and regulate ghost guns. The next section of the bill talks about record requirements for dealers. Actually, I'm on section 7. And I just have a question here. I noticed in Section 7 it says that we're going to add long guns to the bound book statute, which is the registration that remains inside the gun dealer's store. And I'm just curious about that because do we still use the bound book for pistols and revolvers through you, Madam President?
Senator Winfield.
One moment for me to catch up with Senator Sampson, Madam President.
Section 7, yeah. I'm looking for this spot too.
Madam President,
Senator Winfield.
what I can say about that section is that that section, what's happening there is there's a modification in that section of the pistol and revolver to the term firearm. And then there's, at the bottom of the section, there is more language about the investigators. But what this does is just modify a section that's sitting in law. What people do in action, but we are modifying law that sits on the books currently. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. I appreciate that answer. I'm just looking at the language, and I see for myself that really what we've done is change pistol or revolver to firearm, but the definition of firearm now includes long guns. So this is not simply a change in language, but it's also a change in policy that we will now be keeping track of long guns in the what has been referred to throughout history as the bound book at the gun dealer. And my question was more general about whether or not we even use this process anymore. My understanding is that now the state police are actually keeping track of all of the firearm transactions that take place. They even have the ability to look up, who owns what firearms. It used to be that the record was kept at the gun store on purpose as a way to prevent the state from maintaining a registry of firearms. And over time, somehow that protection for the citizens of Connecticut has been lost. And now I just find it funny to see this actual section in law show up here where we're going to begin to expand the bound book requirement. And I'm just curious whether or not this actually is in practice. I see it's still in statute, so I imagine the gun store is still obligated to follow it, and they'll be obligated to follow this change. But I don't know that it's even being used anymore to any level. I won't put the chairman on the spot. If he has something to add about it, I would be delighted to hear if he's got any information. But otherwise, I'm going to move on to Section 8 of the bill, which is also regarding firearm dealers. And I looked through this section. It looks like a number of requirements that will be placed on firearm dealers. I suspect they do many of these things already. I wish that I knew more about their activities to find out whether there was anything really significantly onerous in these requirements. But there is something that I did find that really did give me pause, and that is on lines 513 through around 544. There is a process that is established which effectively says that if a firearm dealer is not living up to the requirements in this section of the bill, and one of them is that they have to do an inventory reconciliation each year, that the police can reach out to them and tell them that they must cure that deficiency. And then after a period of time, I don't remember exactly what it was 30 days or 90 days or something, that if they had not cured the deficiency, that law enforcement officer can actually issue a stop sale order and tell that business that they can no longer engage in retail sales. And I find that surprising and somewhat shocking because we do not empower the police to be judge and jury, Madam President. We don't do that. Police officers perform a very valuable service in our society, but they don't get to decide who's guilty. They can charge someone with a crime. They can apprehend someone if the circumstances warrant it. But they don't get to decide that someone's guilty and also be able to shut down someone's business. And I have a grave concern about this section, which effectively leaves out any due process for the gun store owner. And I'm just curious if this is done in any other industry. Through you, Madam President.
Senator Winfield.
Thank you, and through you, Madam President. As I think the senator knows, that's a large question about any other industry, but I'm not aware of it being done in any of the industries I am aware of. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. That's why I asked the broad question, because I didn't think there would be any other industry, and I certainly won't hold the good chairman to complete 100% accuracy on that. But I don't think that happens anywhere. And I recognize we're dealing with firearms, but it shouldn't matter. People in this country are innocent until proven guilty. We have due process for a reason. I think that this section, on its face, is unlawful. And I have no doubt that it will end up resulting in some sort of legal challenge. And I'll just point out, by the way, that this bill is ripe for legal challenges. I think I've made that clear already. And the thing is that those legal challenges are not free. You know, if the state of Connecticut has to defend this bill and pay the Attorney General and staff to, to work on a case to defend the state for the policy that it's made, that costs money. That costs taxpayer money. And I don't like the idea of throwing tax money down the drain by having to defend poorly written policy that's vague, unclear, and in this case, on its face, in direct conflict with everything that our system of justice requires. Due process is a key ingredient to the protection of citizens in America. This is another situation where, if I had the opportunity, I might have offered an amendment to restore due process for gun stores before they are ordered to stop sales. We wouldn't do this to any other industry, and it seems to me that this section of this bill is being written in a way that specifically targets gun stores, as if they have less right to operate, even though they are doing nothing that is unlawful. Okay, just moving on. Section 9 is coming up next, and this one is the referred to several times by proponents as a ban on the bulk sales of firearms, but it simply limits the firearm purchases to 3 firearms per 30 days. I own a few firearms. I don't think I've ever purchased more than 3 in 30 days. I probably haven't come close, and a lot of people wouldn't. And I can understand maybe a layman saying, I don't see a reason for that. And gee, that's one of the greatest sentences that's been misused by policymakers since the dawn of time, is that they don't see a reason why anyone else should be able to engage in some other activity. But thankfully, in America, we don't do that often. We don't try and determine what other people should be allowed to do as long as it's not harming anyone else. But there are exceptions, and this bill is one of them, where the proponents have taken upon themselves to take yet another victimless activity. It's not hurting anyone. Now, if somebody is buying many guns and reselling them to criminals that are engaged in criminal activity or something like that, then yes. But that's already a crime. So how far down the barrel should we reach to try and make someone a criminal when they've done nothing criminal? The simple purchase of firearms is lawful. And I don't know why the number 3 was chosen versus any other number. Maybe the chairman can let me know why the number 3 was chosen as a limit. Through you.
Senator Winfield.
Thank you, Madam President. While I am defending the bill, I don't know particularly why the number 3 was chosen. I wasn't a part of that process. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. Does the chairman feel that 3 is the proper number for good policy?
Senator Winfield.
Madam President, I think as Senator Sampson alluded to, I think what people are, what the people who were involved in constructing the bill were trying to do is think about the issue of what we sometimes call bulk purchasing, and making sure that those who have the right to purchase guns can purchase guns, but that they're not purchasing so many guns that were likely in a situation of bulk purchasing. And so the number 3 was arrived at through whatever process they did, but I think they believed that 3 was appropriate, believing that one is able to purchase guns they might need, but that 36 a year is quite a number of guns, and likely not to be exceeded by almost anyone. Through you, Madam President.
Senator Sampson.
Well, thank you very much, Madam President. I appreciate those responses. I mean, I have a lot to say about the chairman's comments. I'm surprised to hear that he was not involved in the creation of this bill as the chairman of the Judiciary Committee. But the bigger issue is that it's not 36 guns in a year. It's 4 guns in a period of 30 days that will get you into trouble, because the limit is 3 per 30 days. Am I incorrect about that? Through you, Madam President.
Senator Winfield.
I'm not sure there's a difference in what is being said and what I said. The number total would be 36 in the year. But yes, if you purchase 4 in the 30 days, you would get into trouble.
Senator Sampson.
Thank you very much, Madam President. I would say that's a great distinction. There is a big difference between saying someone might purchase more than 3 guns in 30 days or more than 36 guns in a year. I can see plenty of situations where someone might buy more than 3 of anything within 30 days, but that doesn't mean that they are going to continue to purchase things and items at that rate. I also note that the bill sets a different standard for firearm instructors, where they are able to purchase 6. That's a good question why, but I won't bother asking. It's an arbitrary number, as is the number 3. They could have easily made this bill say 2 or 5 or 26 or 1. And in fact, I know that the original proposal was no more than 1 firearm per month. So I suppose that would have been a maximum of 1, and 2 would have been enough to get a person in trouble. This seems rather absurd to me. How on earth does preventing a lawful firearm purchase stop crime? Through you, Madam President.
Senator Winfield.
Again, the senator himself explained it earlier. There are persons who lawfully purchase firearms and then allow those firearms to be used in an illegal manner. I think what is being done here is thinking about, and I'm glad the senator brought up the fact that it was originally 1. There was concern about the purchase of only 1. There were discussions which I wasn't directly involved in. As you know, we have plenty of bills in the Judiciary Committee. We split up the work. People get involved. You are sometimes involved in those processes, and I am not. So it's not a matter of whether the chair is involved or not. There's a way of moving the business forward. I'm consulted about that, the fact that we have made a decision, wrapped into it, but I'm not directly involved in that process. But the point is, we went from 1 to 3 to take into account that people do have a right to purchase guns, and what we did not want to do was limit it so much as to effectively obviate that right. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. And again, I certainly appreciate the response from the chairman. I don't know there was an answer in there about how this stops crime, other than the suggestion that it has something to do with bulk purchasing firearms for the purpose of making straw purchases or trafficking. But again, that's already a crime. That is already a crime, and we are certainly within our rights as a state to empower the authorities to arrest and prosecute and convict people for that crime. I look at Table 1 of this OLR report, which I keep sharing with folks because I do think it's really indicative of what's going on, and I look to see that in 2022, there were 103 charges of illegally transferring or purchase a pistol or revolver, 103, and 90 of those were nollied, and 6 of those were dismissed. So out of those, only 7 were found guilty. So 93% of those crimes were dismissed. Now, I don't know if that's a matter of, wrongful prosecution or the officers involved in making the arrests were had the wrong evidence. I don't know what the reasons are. I can't dig into this, but I can tell you that there's a pattern of a lack of prosecution. I also don't see that this happens a tremendous number of times in our state, and I would point out that when we find people that are involved in criminal activity with firearms, they're usually kind of garbage firearms, to put it bluntly. If anyone in this room is curious, a typical handgun, even a relatively inexpensive one, to purchase one at a gun dealer is around $500. And certainly they go up from there. Whereas illegally obtained stolen firearms are often sold illegally for well under $100. I don't see how limiting lawful purchases, and in Connecticut, we have some of the strictest gun laws in the country, right? That's what people like to say. When you go into the gun store to buy a firearm, a handgun, you've got to go through a background check. They know who you are. It's not a mystery. You've got to give them your information. You've got to give them your pistol permit. You go through an insta-check to make sure that you're not in the system. So there's a record of that purchase. And presumably there will be a record if that gun is used in a crime down the road. But according to these crime statistics that I'm looking at, and this goes back to 2013, and you can look at this data, there's very, very few instances of the crime of trafficking. I mentioned earlier that one of the greatest successes that I've witnessed in this building is the fact that the governor came around to see the value of reinstating the statewide firearm trafficking task force. And I am very hopeful that if there are criminals engaged in trafficking illegal firearms in Connecticut, that we can catch them. I hope so. And I hope that resolves a problem. But for me, this is yet another victimless crime. There is nothing to indicate that someone who is purchasing more than 3 firearms in a month, which has nothing to do with 36 in a year, I'm afraid. It's just 3 in a month. If you go to 4, you're guilty. That is not 36. Why we would set different standards for different people. I don't see that this will work. Remember, that was the first standard I asked. Will this work to prevent criminal behavior in our state? It won't. It's not going to make a darn bit of difference. I also don't believe it lives up to the other tests that I've already asked about. Is the potential benefit of denying these people freedom, is the benefit worth denying the freedom of people to engage in purchasing a firearm and exercising what is not just the purchase of some other product, it is their constitutional right, protected by the U.S. Constitution and our state constitution. This is not something that we just nibble around the edges at. The Constitution says shall not be infringed. And I would submit to everybody in this room telling somebody that they can only buy a certain number of firearms is an infringement. And I really challenge anyone to tell me that it's not. The number is completely arbitrary. And as far as I can tell, there are very few exemptions. Through you, Madam President, if there was a family member, for instance, maybe someone was getting older and they wanted to transfer their firearms to a family member, would they be able to do so? A father to a son, he's got a collection, maybe he's got 10 guns. Would he be able to do that in one transaction? Through you, Madam President.
Senator Winfield.
I'm sorry, Madam President, is the question, would he be able to transfer 10 guns in one transaction?
Senator Sampson.
Yes, that's my question.
Senator Winfield.
Through you, Madam President, that would be more than 3 in a 30-day period, so no.
Senator Sampson.
Yeah, I would follow up that question, Madam President, with asking what harm, why would we make such a transaction illegal to prevent a father from handing down his firearms to a son as he advances in age to the tune of more than 3 per month? Through you, Madam President.
Senator Winfield.
Madam President, I feel like my answer will be unsatisfactory because it's very similar to the answer I gave before about what the point of this section is. I recognize that the senator doesn't agree with those who've put this together and doesn't think it is very effective, but the point is whether it's buying to then sell or transferring potentially to allow for the usage of these guns in ways that maybe we don't want guns used, and recognizing that most gun users are not doing these things. The point is to not allow those types of actions to happen. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I am very curious to know what actions we don't want gun owners to engage in. But more important than that right now is why are we not differentiating from the potential of a criminal activity, someone straw purchasing firearms, and a family member transaction that has no criminal intent whatsoever? Why are we not making that distinction in this piece of legislation? Through you, Madam President.
Senator Sampson.
Winfield.
Oh, sorry. Senator Winfield.
Thank you, Madam President. Madam President, as the senator who has been here long enough to know this certainly knows, when we put together a piece of legislation, there are all kinds of ways that people could imagine it could go. In the construction of this, that just wasn't how it came about. That's how it works when I create a piece of legislation, when Senator Sampson creates a piece of legislation, when the governor suggests a piece of legislation. We could all ask those questions on almost every piece of legislation ever created.
Thank you, Senator Sampson.
Well, thank you, Madam President. I appreciate that answer, but I think that this is a little bit different situation. We are about to pass a law that will deny the ability of a perfectly innocuous transaction between the citizens that we swore to represent and uphold their constitutional rights. So for me, it's a big difference. There is no comparison between someone who's trafficking in firearms, which I would punish to the fullest extent of the law. I might lock them up and throw away the key forever if they were engaged in the illegal trafficking of firearms with the intent for people to be harmed. But that's an entirely different situation than granddad is ready to pass his guns on to his son or grandson or granddaughter. And I think that should be considered a lawful transaction as it is today, and there is absolutely no state interest. I'll remind us that we are bound by numerous restrictions. We just don't get to make any law we want. We don't just say, well, that's a good idea. Let's write it down. We don't get to do that. We have limitations. Our Constitution lays out the framework. We have 2 constitutions we follow, the state and federal constitution. It says we can't interfere with the constitutional rights of our constituents. We can't do that. This section of this bill clearly does that. I mean, to say that you're not infringing on someone's Second Amendment right by saying you can only purchase so many firearms is an absurdity. It's an obvious and glaring attempt to infringe on their Second Amendment right. It's absurd to say otherwise. And when you say it doesn't even matter what the purpose is, it doesn't matter whether they're in the practice of bulk purchasing firearms for straw purchases that will end up in criminal activity, or it's granddad handing down their firearms to a family member without any criminal intent whatsoever. Those are two entirely different things. And to make no distinction in this bill is irresponsible to a significant degree. Madam President, I have an amendment. This one is LCO 9682. I ask that the clerk call this amendment, and I be given leave of the chamber to summarize.
Mr. Clerk.
LCO number 9682, Senate Amendment J.
Senator Sampson.
Thank you very much, Madam President. This amendment that has been called is a paragraph, and it effectively describes several circumstances which we would exempt from the restriction of limiting firearm purchases to 3 per 30 days, and it lists out specific situations, and I'll try my best to read them, even though it's relatively small print. Let me see. Transfer to a museum at a fixed location that is open to the public and displays firearms as part of an educational mission. Transfer made to the transferee's spouse, mother, father, brother, sister, child, grandparent, or grandchild, or a transfer made by an executor, administrator, trustee, or conservator. This is a good amendment. It takes perfectly lawful, harmless activity and removes it from being a crime under the bill that is before us. I move adoption. I'd like a roll call vote.
Thank you. The question is on adoption. We will have a roll call vote as requested. Would anyone like to remark on the amendment? Will you remark on the amendment? Then I will open the voting machine, and Mr. Clerk, please announce the vote.
Immediate roll call vote has been ordered in the Senate. We're voting on Senate Amendment J of House Bill number 6667, an act addressing gun violence. This is 6667. Total number voted 35, total voting yea 12, total voting nay 23, absent not voting 1.
Thank you. The amendment fails. Senator Sampson.
Thank you very much, Mr. President. As I've said before, there seems to be a pattern here, which is that even the strongest case to make a change in this this bill doesn't seem to go anywhere, and I find that frustrating. As I've mentioned in the past, you know, we each of us represent a significant number of people in this state, and we are charged with being their voice. And I don't want to go so far as to say that I've never had an amendment adopted. I've had several amendments adopted in the past, but on some of these, you know, larger contentious bills, it seems like it makes no difference how thoughtful or necessary even an amendment might be. It's just rejected out of hand by the majority, and that's unfortunate. I think I made a good case for the fact that limiting the number of firearm purchases in a month is certainly an infringement on the citizens' Second Amendment rights that we represent. That I don't believe it's going to be effective at stopping crime, since people are not going to make lawful firearm purchases for the purpose of trafficking in firearms. They're going to purchase illegally obtained firearms for that purpose. For one, they're a lot less expensive, and criminals don't exactly like, you know, to expose their identities. And anyone who's got a pistol permit and can make a lawful firearm purchase, I can assure you, they have no criminal record for one thing, and they want to maintain that right. They're not inclined to use their pistol permit for nefarious purposes, and the data proves that over and over again. this section of the bill fails all the tests. Will it work? No. Will it, does the benefit outweigh the penalty that we're giving to our constituents with the denial of their rights? Is there a disparate impact? I don't know. Will certain people be held to a higher standard as a result? We already know that there's a separate limit for people who qualify as firearm instructors. And the constitutional questions certainly are not met. Remember that in order for a gun control law to meet constitutional muster, you have to be able to identify a similar provision at the time the Second Amendment was adopted. And I don't believe there was any limitation on people on the number of firearms they could lawfully purchase if they were a lawful purchaser of firearms. That right there, I believe, would be struck down by the Supreme Court. And as I said, I only hope that we get there. I'm going to move on to Section 11. And Section 11 is a section that deals with raising the required age for the purchase of a semi-automatic rifle to age 21. I've got a lot of notes here, so please bear with me. I just want to find the right thing that I'm looking at. So this says that it prohibits the transfer of any semi-automatic center-fire rifle that accepts a magazine exceeding 5 rounds to any person under 21 years old. So again, even if we ask our tests one more time, what is the purpose of this legislation? What do we hope to achieve by limiting these purchases? Through you, Mr. President.
Thank you, Senator Sampson. Senator Winfield.
Other than prohibiting the sale to under 21s, is that the question?
Senator Sampson.
Thank you, Mr. President. No, sir. I'm not asking what the policy is. I do know that. I'm wondering what the goal is. What do we hope to achieve by denying someone who is of lawful age as a majority age, 18, denying them the right to purchase a semi-automatic rifle until they're age 21?
Senator Winfield.
Thank you, Mr. President. In another perhaps unsatisfactory answer, I will not always be able to give you what the thinking of others is. I wish I actually had that capacity, but I can tell you what's sitting in front of us, and sometimes I can give you people's thinking.
Senator Sampson.
Mr. President, I'm sorry, I didn't hear that last bit of the answer.
Senator Winfield.
I said, and sometimes I can give you the thinking because sometimes I've been privy to what the thinking behind it is. I can tell you what the bill does.
Senator Sampson.
Understood. Thank you very much, Mr. President. Yeah, so I don't see a purpose that will be served by this. Again, another victimless crime. I don't know if there is some sort of inference to be made that someone that is a specific age is more or less likely to commit a crime than another person. But what I'm witnessing here is yet another victimless crime that will ultimately impede the rights of people that we represent. It seems clear to me that we are slowly but surely closing in on an attempt to eliminate the purchase of any type of semi-automatic firearm, and this is just another step in that direction. I don't know that you can even manage to find a semi-automatic rifle that has less than a 5-round magazine. But I guess the thing that stands out for me is not just the fact that we're talking about yet another provision that fails all the tests that I suggested that we needed to meet. It's not going to stop crime. It may have disparate impact. Doesn't show any viable benefit that's worth denying someone their Second Amendment right to me. And I look at this and I see, what about military personnel? It seems outrageous to me that you can serve in the military in any of our armed forces at age 18, where certainly you can be trained and shoot a fully automatic firearm. You may even end up in a war. You might even have to kill another person. And yet when you return home, you will not have the right. Actually, that's not true. You will still have the right. But you will be denied by Connecticut law to purchase a semi-automatic rifle in Connecticut if you are not yet age 21. And without some compelling public policy reason, some compelling state interest, I believe this fails all those tests. And again, another thing that I don't believe is going to fight any crime whatsoever and not improve the lives of Connecticut citizens in any way. It is just another infringement. It is just cutting off another finger or another limb. It is just shocking to me that this type of policy can end up in a bill without any real significant review. You know, we heard a number of folks around the circle tonight make very engaging, emotional, and passionate speeches about this legislation. But the one thing I noticed about every one of those speeches is no one touched the bill. No one touched a word of the policy that's actually here. Because the policy doesn't match the rhetoric. The rhetoric is how we're going to save people. I want to save people. To imply somehow that the people that are voting for this bill are more interested in saving people and protecting people and preventing gun violence than people that are not is an absurdity. And when I look at the language in the bill, it's even more absurd. Because nothing in this bill has yet shown me that it involves fighting the potential of gun violence in our future. Let's move on to Section 12, which is the home storage provision. This particular section says that it prohibits storing or keeping any firearm on any premises under such person's control unless such firearm is in a securely locked box or other container or in a manner which a reasonable person would be believed to be secure. So talk about bills that are written with words that need to be clarified. And again, I don't really relish the idea of bugging the chairman to try and come up with answers for me on what these words are, but I'm hopeful that he can give me a little bit more than what I just read from the bill. What, for example, would be considered a reasonable interpretation of secure, and what does secure mean? And furthermore, going on, what does within close proximity mean? Through you, Mr. President, if there's any further enlightenment that I can get on the language in that sentence, I'd appreciate it.
Senator Winfield.
Through you, Mr. Chair. Again, for reading of a bill where the language isn't specifically laid out as to a definition, as we have sometimes in a definitional section, you would use the dictionary definition of that. And so it's where I believe Senator Sampson is, it's within such close proximity thereto that such person can readily retrieve and use such firearm. So if the person could not readily retrieve and use the firearm, they would fail what would be the test of that. Also, I would suggest that we have been doing this as this is a modification of law that sits already, so we would continue in the manner that we are. What we're doing there is changing which persons we're talking about it applies to, through you, Mr. President.
Thank you, Senator Sampson.
Thank you, Mr. President, and thank you, Mr. Chairman, for those answers. And I understand this is a difficult thing to do, to interpret this language in the bill. But I was hopeful that since we are talking about existing law, that we're simply expanding to cover more individuals and more circumstances, that there might be some record, some previous data or interpretation that might tell us a little bit more about what it means for a reasonable person believing to be secure. And the idea behind within close proximity being further characterized as readily to retrieve and use the firearm, that could cover a lot of different things in my mind. It might mean something as close as you've got to be able to reach for it within a second. But I might also say that I can readily go in and retrieve my cell phone off the counter of the kitchen when I'm in the car. So I don't really know what readily retrieve and use really boils down to. And I guess that's my difficulty here, because this section, as it is existing law that's being expanded, in my mind, is one of the worst policies ever adopted by this chamber. It was adopted for emotional circumstances, and it effectively makes criminals out of innocent people for the behavior of others. And I don't know why we'd ever engage in such a thing. Let me ask a question. How about if the firearm is in a hidden location? Would that qualify as a suitable way to secure a firearm? Through you, Mr. President.
Senator Winfield.
Thank you, Mr. President, and through you, I will definitely answer that question. But I just want to say that we're not reading parts of the sentence. We're reading the whole sentence, and the whole sentence that we were just talking about with the readily retrieve is close proximity, and then we get to readily retrieve it. So there is the notion in the sentence that it has to be proximate to the individual, right? So if you have to go through a door into your house to retrieve it off the counter, that is certainly not close. There's not the proximity issue, and so yes, you might be able to readily retrieve it, but I think in combination, that's how you get to what a reasonable person would interpret. And I think perhaps there's a disagreement here, but I think a reasonable person would understand what we're talking about. I can readily retrieve something I can see, but I certainly can't see through a door, and would not be able to readily retrieve that and also meet the close proximity issue. It's late. I forgot the second part.
Senator Sampson.
Thank you, Mr. Chairman, and I appreciate that answer. But I don't think it's as clear as we're trying to make it here. Close proximity means a lot of different things based on your circumstances. You know, when I'm driving home from across the state, I might say that I'm in close proximity to home when I'm 5 minutes away. That's obviously different than something that is within a couple of feet where you might be able to grab it. And we're talking about a situation where we're inside someone's home. So if something that is in an entirely different room, does that count as close proximity, yes or no? Again, I didn't ask a question, I'm just being rhetorical. I don't want to spend a lot of time on areas where we're not going to have value in our conversation. Because I think that it's just a matter of this language is vague. It will be up for interpretation in a court. And I think that's unfortunate. I think that we should work harder to try and spell out this type of policy in a way that is very, very clear. It's one of the tenets of how we do things in America. We write our laws down. I've said this several times in the past on this floor, that we have to get away from allowing people in positions of authority to determine whether or not things are acceptable or approved by them. In America, we have a system of laws and justice that we actually write down. and we write it down on purpose so that it is crystal clear to everyone what it means, and so that it applies to everyone equally. It's not going to be interpreted differently by one judge versus another. We want to avoid that as much as possible by making clear laws. And this, for me, is a very vague, and it's disconcerting because the policy that's here could end up making someone guilty of a very, very significant crime. Through you, Mr. President, what was the penalty for a violation of this section of the bill?
Senator Winfield.
Thank you, Mr. President. I have to go back to that section. Sorry. Mr. President, you are in section 12. I'm sorry, you're in section 12?
Senator Sampson.
Through you, Mr. President, I was referring to Section 12 because that is the home storage policy, the where the crime is laid out. But the penalty, I believe, is in Section 20. And for the record, I've already found it. It's criminally negligent storage of a firearm is a Class D felony. This is a very serious crime that, or a penalty for a crime for simply failing to store your firearm in your own home in a way that satisfies this body. And I find it interesting that the legislature and those who will vote for this bill think it's okay to enter into someone's home and suggest that they know how best to store a firearm. This bill, when it was originally drafted and passed in 2019, the policy that's before us applied only in circumstances where you had a person living in the same household under the age of 16 as a means to ensure that the adults in the house were responsible and would secure the firearm. This particular section expands this policy to include even a single adult person. So it makes me wonder. I mean, for me, I'm a single person. No one goes into my house without permission. I don't have any children. Would simply locking my door behind me be enough to satisfy this requirement through you, Mr. President?
Senator Sampson. Senator Winfield.
One moment, Mr. President.
Senate will stand at peace.
Mr. President, the section 12, which describes what is in play here, suggests that the person has to have this, as we talked about before, the securely locked box or container. That we were going back and forth about whether it was reasonable. So that would suggest that the locking of the door does not meet the requirements of that section through you, Mr. President.
Senator Sampson.
Thank you, Mr. President. I appreciate the clarification. There is some speculation because it says in a securely locked box or other container or in a manner which a reasonable person would believe to be secure. Now, I consider myself to be a reasonable person, and I would say that my firearm is secure if I lock it in a room in my house or if I lock it in my house and no one else is there. And I just want to clarify one last time that either I'm an unreasonable person or that's not what that means, through you.
Senator Winfield.
Don't take the bait.
Mr. President, given that we are in a conversation about the house itself as the unit of analysis, I don't think that the house, because that's how it was framed, could be considered the security. And so it would have to be something inside the house that provides that security. So the locking of the door of the house, I don't believe meets the requirements.
Senator Sampson.
All right, thank you, Mr. President. That's unfortunate because I think that, in my opinion, since this bill now impacts every person, including those that have no children or 16-year-olds in their household, I don't think it's reasonable to suggest that someone has got to go through these additional requirements. The fact that people purchase a firearm for self-defense, among many other reasons, and it's a conversation that we ought to have at some point, why people buy firearms. But one of the reasons why they purchase them is for self-defense, for home protection, in case something goes bump in the night, in case there is an intruder. And this section of the bill flies in the face of the ability for someone to be able to protect themselves. If you are going to require someone to lock up their firearm, even when it's not a situation where there's the potential for a juvenile or a child to come in contact with the firearm, then you're effectively diminishing the ability of an adult person, the permit holder, firearm owner themselves, from being able to get at their own firearm to maybe save their life. I don't think that's good policy. Back to the tests. Will it work? No. I think it's going to make people victims, is what's going to happen. I think that people who would have otherwise been able to stop something bad from happening will become victims. And I think that's unfortunate. And I do think there will be a disparate impact because I think there are people that will live in higher crime areas of our state that will be more likely to become victims. I've got an amendment, Mr. President. It is LCO 9478. I ask that it be called and I be given leave in the chamber to summarize.
Mr. Clerk.
LCO 9478, Senate Amendment K.
Senator Sampson, go ahead.
Thank you very much, Mr. President. This is a very simple amendment. In line 1037, after the word "or," we insert "in a locked or secured room or locked house or apartment." This will add the ability to include simply locking the firearm in a room behind a locked door or locked in the home when you leave will qualify as secured and not ultimately lead someone into a position where they might end up in violation of this law if passed. I move adoption, and I'd like a roll call vote.
Thank you. Would anyone like to comment on this amendment? Seeing no comment, the machine will be open.
Immediate roll call has been ordered in the Senate. This is Senate Amendment K, House Bill 6667, an act addressing gun violence. Senate Amendment K of House Bill 6667. Total number voting 35, total voting yea 12, total voting nay 23. Absent not voting 1.
The amendment fails. Senator Sampson.
Thank you very much, Mr. President. Another unfortunate, what I think is a common sense amendment that would have clarified certainly that you could get by with locking a door to your home or locking your house, assuming, like I said, that this would apply in situations where you're talking about a single person. There are so many questions about this section about what actually applies. It says a secure locked box or other container. How about a briefcase, for example? Mr. President, let me ask that question. What if you stored your firearm in a briefcase that was locked by the bed and someone stole that from your property Would that be considered properly stored through you?
Senator Winfield.
Through you, Mr. President, I think as every situation we're ever going to talk about here it's going to depend on what we're talking about in terms of a briefcase. There are briefcases that are not the type of briefcase I think anyone would think of as secure, even if it had a lock on it. And then there are briefcases that are as secure as anything one might think of as a secure box. So I think the question really depends on the briefcase itself, through you, Mr. President.
Senator Sampson.
Thank you very much, Mr. President. And I know that I already asked this question, but I want to make sure that we revisit. What if the owner of the firearm placed the firearm in a secret location that was hidden from view, where someone entering the room would not be able to know it was there, but the owner did? Would that be considered a secure location? Through you.
Senator Winfield.
Thank you, Mr. President. And through you, Mr. President, I think that would be considered a hidden location, but secure, no, not necessarily, unless it were locked away in a manner that was secure. You could hide it under a pillow, behind a dresser, a myriad of places that are not secure but hidden. Through you, Mr. President.
Senator Sampson.
Thank you very much, Mr. President. Yeah, no, those are disappointing answers because, as I mentioned, people purchase firearms for their personal protection. And you would have an expectation, in my mind, that if you lived alone, that you could store your firearm within close proximity, close reach, and have the ability to reach it quickly in case you needed to. And this bill seems to say that you can't do that. If you do that, you could end up in violation of this bill that's before us. And as I mentioned, the penalty is a Class D felony. This is not small potatoes here. This is a serious, serious crime. And I also understand that this particular policy includes a provision for strict liability. Is that correct through you, Mr. President?
Senator Winfield.
Through you, Mr. President, I believe the answer to your question is yes. I will also note, maybe we're going there anyway. I will also note, just for clarity, that if the device, if the gun that we were talking about is reported stolen, that changes whether or not the owner is criminally liable. Through you, Mr. President.
Senator Sampson.
Thank you very much, Mr. President. I'm actually trying to find that section in the bill before us, because it seems to me that there is a requirement that the person is also as a result of unlawful entry to the premises. And that begs the question, what if I let someone into my home, plumber, for example, and unbeknownst to me, they when I left the room, they went into the bedroom and discovered my firearm and took it. Would that satisfy the requirements of the language that is before us? Would I be guilty of a Class D felony? Through you.
Senator Winfield.
Thank you, Mr. President. I'm trying to get, as Senator I'm trying to get myself to the section again. If the question could be posed again, I would appreciate
Senator
it.
Sampson, could you repeat your question, please?
Thank you very much, Mr. President. Yeah, sometimes when it's this late, you can't remember your question. But this time, I think I'm good, which is I asked if you had let someone into your home, a plumber, I used that in my example. So it was not unlawful entry. I allowed them to come inside. But then I left the room, and they used the opportunity to go into the next room, the bedroom, and they found the firearm. Would the requirement for unlawful entry mitigate the crime being described in the policy before us? And would I still be guilty of a Class D felony?
Senator Winfield.
Thank you, Mr. President. Through you, I'm unclear. I thought I heard that the homeowner allowed the person in, and then I think I'm being asked, would the requirement for unlawful entry pertain? But there was no unlawful entry, so I'm confused as to what the question is.
Senator Sampson.
Thank you very much, Mr. President. What I'm asking is that the language says that the provisions of the section shall not apply, this is the language from the bill, if the firearm, as a result of unlawful entry to any premises by any person, is stolen. I'm not sure that the word stolen is in there. Forgive me, that might be my own language. But there is a requirement for unlawful entry, and I'm suggesting that not every time that this situation might arise could be a result of unlawful entry. You might let someone in your home for some specific purpose, but they are not a family member, they're not someone you're close with, and maybe they cannot be monitored at all times. And I'm just curious, because this bill that is before us, this section probably concerns me more than any other, because the first job that we have as lawmakers is to do no harm. That's the very first job that we have. And what I see from this bill is we are telling people not to have their firearm available for self-defense. We're telling them that they have to secure it in a manner that prevents them from being able to use it. For me, that's going to end up with more tragedies, not less. And I'm just trying to clarify if whether or not there has to be unlawful entry for you to not be responsible. Through you, Mr. President.
Senator Winfield.
Through you, Mr. President, I will say that I believe Senator Sampson's in lines 1243 through 1246. I just want to make sure that I'm oriented correctly. And if that's what we're referring to, then that section requires that in order for the provisions of the section that we are in, which is section 22, not apply, that the person who obtained the firearm obtained it as a result of an unlawful entry to any of the premises. And the situation that was described, there was a lawful entry onto the premises. That's why I asked the question. And so it doesn't seem that a question about whether the unlawful entry would pertain here could possibly pertain because they were allowed lawfully into the premises. Through you, Mr. President.
Thank you. Senator Sampson.
Thank you very much, Mr. President. And forgive me if I was not clear and we were talking past each other. This section describes a situation where the section of the bill will not apply, where you would be free from being guilty of criminally negligent storage of a firearm, which is a Class D felony. And the only exception that is listed here is if a person obtains the firearm as a result of unlawful entry, and then the firearm is stolen, and then it is also reported stolen. So that's a lot of requirements to put on the homeowner, the firearm owner. And I'm just asking that whether or not this would absolve the owner if it was lawful entry, but the rest of those circumstances applied. And I think I already know the answer, which is that it won't. So you will be just as guilty if there's a lawful entry. You let the plumber into your house and he steals your firearm, it's used illegally, you're guilty of a criminally negligent storage of a firearm. We're making criminals out of victims. That's what this section does. We're making criminals out of victims. You have your firearm stolen by someone, and now you're the victim, but no, you're guilty. It doesn't make a lot of sense. And telling people how they should store their firearm in their house, to me, doesn't make a lot of sense either. because I think that there are a lot of people that live alone. They might live in dangerous neighborhoods. They might feel comfortable having their firearm in a place that I would describe as secure, but it doesn't meet the requirements of the bill because it's behind a locked door, or because it's in a hidden location, or even in a nightstand by the bed. I think once you enter into someone's home, particularly if they are a single person or there's no children involved, you've gone too far. I don't think you have a right to enter into someone's home to tell them how to store their firearm. And I think the section also is completely unclear, since my question about a briefcase will depend on the briefcase. Well, I think everything in this section depends on interpretation. Close proximity, reasonable person, these are all vague terms. We should not be writing policy in vague terms. And, I suppose what it's trying to say is that you need to store your firearm in a safe. And that's all well and good. And people that own firearms often do have safes. And I've even proposed legislation here to give a tax credit for people to buy a safe, because I would like them to store their firearms responsibly. But that's a different situation. Some people also want to store at least one firearm in a way they can get to it, so that they can access it in an emergency situation when necessary. And I believe that this bill has the potential to make criminals out of those people when they're simply trying to protect themselves. I don't see that as a smart policy. And in fact, Mr. President, I'm going to offer another amendment. This one is LCO 9572. I ask that the clerk call this amendment, and I be given the opportunity to summarize it.
Mr. Clerk.
LCO number 9572, Senate Amendment L.
Senator Sampson.
Thank you very much, Mr. President. Very straightforward amendment. What I'm trying to do is eliminate all these other requirements for the exemption from this bill. This section under the proposal says it will only not apply if there's unlawful entry and the firearm is stolen and then it is reported stolen. Now, somebody may not even realize that. So I am offering this amendment, which changes that effectively to simply say that if the firearm is stolen, you're covered. Because to me, the situation about unlawful entry is an important one. You may let someone into your house. They may steal your firearm. You may not even know about it. And the fact that we would make someone who is a victim in that case into a criminal, to me, is an absurdity. So I move adoption of this amendment because I believe it hits the goal of the policy before us without making it so broad that it's going to capture people needlessly. And I'd like a roll call vote. Thank you.
Sure. Question is on adoption. Would anyone like to comment on this amendment? Senator Winfield. Senator Winfield. Oops. Can you get Rhonda? Can you turn Senator Winfield?
Thank you. It's a little. I thank you, Mr. President, and through you, Mr. President, I appreciate the effort at the amendment. I don't believe that the statement that it achieves the goal is correct. I think the goal is for individuals to follow what was in Section 12 and securely store their firearms in a manner that we were doing before if a minor were in a home, and now without the minor in a home. Doing what we are doing here suggests that if someone comes into the home and takes that firearm and you follow that process, it's different than if you didn't follow the process. This amendment would change that completely, and so I would advise an objection.
Thank you. Would you remark further? Would you remark further? I am turning the machine on. Mr. Clark, please call for the vote. Senators can vote now.
Immediate roll call vote has been ordered in the Senate. An immediate roll call vote has been ordered in the Senate. We're voting on Senate Amendment L. Senate Amendment L, House Bill 6667. Total number voting 35, total voting yea 12, total voting nay 23, absent not voting 1.
The amendment fails. Senator Sampson.
Thank you very much, Mr. President. Yes, another amendment, which I think was well intended, doesn't undermine even the intent of the bill. It's more of a clarification, but yet fails on a party line. I thought we were talking about some confusing items before, but I'm about to venture into the discussion on assault weapons. And that can be rather confusing if you're new to Connecticut law. So Section 15 is a short section which effectively says that you can surrender your assault weapon prior to December 31st, I believe it is, without a penalty. Actually, I'm incorrect about that. I believe the date is April 30th, 2024. Because on May 1st, if you fail to do so, you will become a felon. And I have so many questions about this. But the very first question I have through you, Mr. President, is how are we going to notify people that own these particular firearms that they must do this prior to May 1st, 2024? I would hate the idea that simply because we are passing some text in this circle about the ownership of a piece of property without any criminal behavior, without anyone hurt or injured, that we would make someone a felon. Through you.
Senator Winfield.
Thank you, Mr. President. And through you, I believe the question is about the part about how does an individual know, which I believe is really what does the bill say about that, and the bill is silent on that portion. Through you, Mr. President.
Senator Sampson.
Yeah, thank you, Mr. President. Yeah, the bill is silent on that. So I don't know how many people own these types of firearms. I think there is some data, actually, that I saw that there was around 80,000 firearms that fall into this category in Connecticut. I'm going to just pull that up really quick. 88,766 firearms in the state weapons registry database. How many people are going to miss the fact that this has become a law? I'd venture to guess it's going to be more than one. And effectively, even though they haven't hurt a soul, even though they bought their firearm lawfully, they didn't break a single law, they didn't harm anyone, this bill says that they will become a felon overnight on a random day next year. That doesn't sound like good public policy to me. We have so many debates in this building about how we are going to protect the people that we represent. I have constituents that are concerned about the clear rise in crime in our district. Almost every day, somebody is sending me some sort of Ring camera footage of somebody checking the door handles of the cars in the driveway or trying to steal cars or stealing catalytic converters. I listen to the news each day, and there's an inordinate number of people involved in, I wouldn't say minor crime, maybe not murder, but dangerous activity. Murders, unbelievable increases in shoplifting, bold, brazen type of crimes. Knocking elderly people down, taking their purses. You know, these are things that may have happened through history, but not at the level that they're happening now. And some of my colleagues earlier pointed to just the policies that we've adopted in recent years that have made it So it's crystal clear that criminals gain the upper edge in Connecticut. I don't like that, Mr. President, and I'd like to see a change. But this is simply making someone into a felon for the possession of something that they bought lawfully. Let's talk about assault weapons for a moment. I'll skip ahead to sections 23, 24, and 25, which are described as the new assault weapon ban for something called 2023 assault weapons. First question I would have through you, Mr. President, is what is an assault weapon?
Senator Winfield.
Mr. President, if I could get a moment to catch up with Senator Sampson, I would be happy to answer the question.
Sure. Senate will stand at ease for a bit.
Yes, thank you, Mr. President. The question was about assault weapons, and the section, the first of the three sections that Senator Sampson was asking about, which are 23, 24, 25. On line 1302, it begins the definition of an assault weapon. It's a long definition. It's many lines long. I would ask the senator if he wants me to actually read that entire definition with all of that stuff, or is it good enough to point out where the bill suggests what an assault weapon is through you, Mr. Chair?
Thank you very much, Mr. President. No, that won't be necessary. Maybe I could just ask you some questions about the definition itself. It appears to name a number of firearms by name, and then it describes a bunch of features, which we'll get into in a second. But let me ask you a couple of just basic questions. First, is there anything in this definition about assault weapon suggesting that this is a military rifle? Through you.
Senator Winfield.
Through you, Mr. President, there's nothing that specifically states as, if you look up assault rifles, generally it would say it's a military style and actually describe much of what's in that definition. But there's nothing in the language here that specifically says that, unless one of the specifically named weapons is a military weapon. Through you, Mr. President. So in the beginning, Mr. President, let me just say, in the beginning descriptive part, there's nothing that specifically says that, and then in the particular, I didn't look at every single one of them, there may be a military weapon in there.
Senator Sampson.
Thank you, Mr. President. So it does not say military rifle, and it does not say even military style rifle. But let me ask, do any of the individual firearms that are listed, do we know if any of these were ever used in military service? Through you.
Senator Winfield.
Mr. President, I have not gone through that entire list separately, so I cannot answer that question. If there's more to the question, I'd be happy to try to answer it. That it may be the case. Some of them look like they may have, but I didn't know that was a question I was going to answer.
Senator Sampson.
Thank you very much, Mr. President. I appreciate that. Does it say anything in this section about how these weapons must spray bullets? Through you.
Senator Winfield.
Through you, it doesn't say, it doesn't talk about spraying bullets, Mr. President.
Senator Sampson.
Thank you very much, Mr. President. And forgive me, I'm not trying to be facetious here. It's just that whenever I hear politicians talking about assault weapons in the news media or in their press, they always say that they're military rifles that spray bullets. And yet, our definition of assault weapon doesn't seem to mirror that at all. And that's because that's not an accurate description. It's about time somebody went on the record and actually discussed this for good, to put that issue to bed. The fact of the matter is the military in the United States and elsewhere around the world, they use fully automatic firearms. Those are the ones that might be characterized as spraying bullets. But the firearms that are on this list are all semi-automatic firearms. They do not spray bullets. They fire bullets at the rate of as fast as one could squeeze the trigger. And that's the same exact way Granddad's rifle that's hanging over the mantle works. And the only real significant difference between the items that are on this list and Granddad's rifle that he used for hunting is what it looks like. It's just cosmetic features. It just so happens that technology has occurred in virtually every industry that we're exposed to. Go back to the 1960s, automobiles were big, heavy behemoths. They had chrome bumpers. They weighed a ton. They didn't turn very well. They had bias ply tires. They're totally different. And firearms, too, have changed. Back in the day, they were heavy. They had wooden stocks. Modern firearms, modern sporting rifles, which is what an assault rifle really is, if you're not trying to gin it up to have some sort of political meaning, is nothing more than a modern version of an old rifle. And the difference really is that it looks different because it is different only in the sense that it weighs less, because it's made out of different types of materials. And it's obvious why. Because if you're a hunter or a sportsman, or you have a firearm for some tactical purpose, maybe you're in law enforcement, you want a lightweight firearm. So today, firearms are often made out of plastic. And sometimes that plastic's black. So when you see a black plastic rifle, please understand, it's still a semi-automatic rifle. It doesn't work any differently than any firearm you're accustomed to. It does not spray bullets. In fact, the most common quote-unquote assault rifle is the AR-15. The AR does not stand for assault rifle. It stands for Armalite rifle, which is the company that manufactured it. And that rifle actually fires a relatively small cartridge. And in some respects, it does look very similar to an M16, which is a military rifle that began use during the Vietnam era. But it's not the same firearm. It doesn't have any interchangeable parts, and it doesn't work the same. And it is certainly not a fully automatic gun. So let me ask a further question, Mr. President, through you. Is there a difference between what I see categorized here as a 2023 assault weapon? Is that something different than a regular, quote-unquote, assault weapon? Through you.
Senator Winfield.
Mr.
Senate will come back to order.
Thank you, Mr. President.
Senator Winfield.
So in the bill, online, I just lost my line again. One moment. On line 1506 of the bill, it has 2023 assault weapon. What it says is it means any assault weapon described in any provision of subparagraph G to I inclusion of subdivision 1 of the section that we're in. So go back to subdivision 1. And I believe that would put us online. Let me just double check. Sorry to try to jump around. That would put us on line 1421 through 1451 to describe what a 2023 assault weapon is. Through you, Mr. President.
Senator Sampson.
Thank you very much, Mr. President, and I appreciate the answer from the text of the bill. And I won't try and drive the good chairman crazy by trying to elaborate any further than indicating the lines on the bill. I knew it was a complicated question, and it is a complicated question because the fact of the matter is that we have had several different bits of legislation federally and in this state that propose to identify what is an assault weapon, and that has changed over time. I would ask another question, which is a 2023 assault weapon different than other assault weapons? Through you?
Senator Winfield.
Thank you, Mr. President. Through you. Well, I suppose it would be different than others because these are assault weapons that are being added to the provisions here, but I'm not sure what the questioner means by different. So clarify. Should he need to clarify the question?
Through you, Mr. President. These are honestly not trick questions, even though the answers are confusing. And the reason why I ask is to illustrate that I'm asking the proponent of the bill, I'm asking the chairman of the Judiciary Committee, with the bill before us, discussing this as we're about to pass it into law. And these questions are almost impossible to answer. How on earth is the average person, somebody that we represent, supposed to figure this out? How are they supposed to understand this section? It is unbelievably confusing because it takes into consideration the fact that there was a ban of certain types of firearms that were labeled as assault weapons prior to 1994. There was another ban on assault weapons that was passed in the wake of the terrible tragedy at Sandy Hook we discussed earlier. And today, there is yet another definition for assault weapon. Are these three different kinds of assault weapons? Pre-94, after Sandy Hook, and now the 2023 assault weapon? Through you, Mr. President?
Senator Winfield.
Again, thank you. And again, and I'm trying to be respectful of the questioner, but when you ask the question, is something different? There are many ways that things can be different. And so I was asking for clarification. I got none there. I am trying to answer your questions, and clarification would have been useful, but since I did not get that, I will just make an attempt to explain what is before us. So if you're in line 1421, we had a list of, in the conversation we had about assault rifles, we had a list of what they were. I think what is happening in 1421 is it's saying if you have a pistol, a revolver, a rifle, a shotgun, whether it was listed in that subparagraph, and yes, the description of what it is very much what we talk about when we talk about these types of weapons, is trying to get at other types of weapons that weren't caught up in that. And that's why I was asking the question about what was meant by is it different, through you, Mr. President.
Senator Sampson.
Thank you very much, Mr. President. I will help out the chairman and say, yes, there is a difference between those three different categories of quote-unquote assault weapons. And I will tell you that it's very difficult for me to say that term because I know how political that term is. It means absolutely nothing. You can tell by the fact that sometimes we add new firearms to the list. So in 2022, not an assault weapon. In 2023, assault weapon. Well, how is that possible? An assault weapon, as I heard someone describe, I think it might have been Senator Kelly actually, say recently that an assault weapon is any weapon you assault someone with. And if you're not assaulting someone with it, it's not an assault weapon. It's just a firearm or bottled water or whatever you're assaulting someone with. The idea that somehow an inanimate object can have some sort of connotation that makes it more deadly than another firearm when it is in operation the same is what we're discussing when we talk about assault weapons. Because, as I noted very briefly earlier, the only difference between a so-called assault weapon and a non-assault firearm are cosmetic features. That's it. Were you looking to interject, Mr. President?
No, I was just thought that you had finished your sentence. So I was just going to see if there was a question.
Not yet, Mr. President. So I'll just describe from my own experience, because I am a responsible, law-abiding gun owner in the state of Connecticut, and I have had to invest a tremendous amount of time to understand all of these laws. And for the fact that the state seems to think that that's okay, number one, to put on their citizens to exercise their Second Amendment right is positively absurd, in my opinion. It shouldn't happen that way. You shouldn't be able to force the people that live in your state that you are responsible to go through mountains of paperwork to understand whether they're complying with the law or not when it comes to their constitutional right. The difference between the three different categories of firearms is what features were considered to make an assault weapon at different times. And I don't want to get into the tremendous detail, but in every case, they're cosmetic features. So let's just look at what makes a 2023 assault weapon according to this section 23 of this bill. It says that it must include at least one of these features, and then any firearm becomes an assault weapon. It says firearms other than pistols, revolvers, rifles, or shotguns. It says include any one of the following: any grip, such as a pistol grip. Now, in the previous ban, you had to have two of these features. If you had two of these cosmetic features, then you had an assault weapon. Today, we are about to change that so you have one of these features. I'm going to list them, and I want people to recognize that not a single one of these things has anything to do with making the gun more deadly. Because it has a pistol grip versus a regular stock. It doesn't change the way it shoots. It doesn't change the way it can fire. It doesn't spray bullets suddenly when you have a pistol grip, for example. If it has a detachable magazine outside of the pistol grip, again, nothing that changes its lethality. A fixed magazine containing more than 10 rounds, and we'll certainly talk about 10 rounds versus not 10 rounds later. A flash suppressor, a threaded barrel, a shroud that is attached to or partially or completely encircles the barrel and permits the shooter to fire the firearm without being burned. A second hand grip, an arm brace, or stabilizing brace that could allow the firearm to be fired from the shoulder, and so on. That's it. Not a single thing that actually changes the function of the firearm to make it more deadly, shoot faster, shoot more deadly rounds. None of that. Absolutely nothing. We are simply labeling categories of firearms based on how they look. I don't like categorizing anything by the way it looks. It's wrong. We should not be arbitrarily separating people or firearms based on their appearance, particularly when it comes to things that make no difference about what's on the inside. This particular bill dramatically expands the assault weapons ban by virtue of capturing many, many firearms that were previously grandfathered. Back in 2013, after the tragedy at Sandy Hook, the first assault weapons ban was passed. And at that time, the legislature said, we are not going to try and capture firearms built prior to 1994. They let them go, grandfathered them in. Today, we're going back to capture those. What's the purpose of that? Do we have any data that these pre-1994 assault weapons are being used in an inordinate number of crimes? No. We don't have any data like that at all. It also says that firearms that were manufactured after 1994 but before the date of that law passage would be considered assault weapons if they had two features, as I said. And as a result, people in the firearm industry, people that shoot firearms, collect firearms, they adapted to the law. And they said, okay, we can't have two features anymore, we'll only have one feature. So since then, for the last decade, that's the type of firearms that have been sold in Connecticut. 86,000 of them, I think I indicated. I don't know if that's the whole number or not. There may be other things that fall in there. But it's a lot of firearms. And today, even though we passed a law a decade ago that was negotiated by all the parties and had the support of the leadership of both Republicans and Democrats in both chambers, and they were trying to be about as aggressive as you could possibly be, I think, in response to that tragedy. They included only certain firearms and left others out. And today, this bill aims to capture just about everything. And for what purpose? Do so-called assault weapons result in a lot of firearm deaths? According to the Uniform Crime Reporting data, it shows that rifles actually account for very few firearm deaths compared to other types of firearms. Handguns, 2019, 6,368 deaths from handguns. Only 364 from rifles. To put that into context, it says knives or cutting instruments, 1,476 deaths. So, seems to me that knives are far more assault weapons than rifles in general, even setting aside these particular types of rifles. There's other things in here too. Hands, fists, feet, that's 600. Even that's more than rifles. Again, rifles is a much broader term, in fact. But you wouldn't know that from listening to politicians who want to find ways to ban more firearms. And every one of them, they'll tell you, well, I support the Second Amendment. They don't support the Second Amendment if they are making an example out of firearms simply for cosmetic features and based on data that says that they are far less of an issue. And in this bill, effectively what the state is telling these people that own these firearms is that you have to surrender your firearm. You have to turn it in by a certain date or you become a felon. Now, in some cases, you have the alternative of registering your firearm. But that means you've got to give your information and paperwork to the state of Connecticut. And I can tell you, I remember having to do that after the bill that passed in 2013. And I can tell you just how frustrating that was. Something that I lawfully purchased that I would never use to harm another person unless they were threatening me or my family, to be treated like I needed to be registered, signed up with the government. so they could keep track of me, to make sure they knew the whereabouts of my firearm. And there's a lot of other people that feel that way too. So it's not surprising that they react poorly when this type of policy comes their way. Because there are hundreds of thousands of so-called assault weapons in Connecticut. And I've not seen one of them jump off a table and do harm to someone. Never. It requires intent. It requires a bad person. It requires somebody with criminal intent. And generally speaking, these firearms are expensive. They're not purchased by people on the street. They are not the type of firearm that ends up being sold illegally or trafficked for a few dollars. Most crime, as I said in my intro, and most violence and most homicides that involve a firearm all fall in the same category. Handgun, illegally obtained, stolen from somewhere, probably another state, in the cities. That's it. If you want to fight crime, if you want to save people's lives, you write policy to go after that. But instead, we have a list of victimless crimes here. Possession of this, possession of that. Possession of something doesn't make you a criminal. So, what else can I say about the assault weapon section? Dare I ask another hard question? Mr. President, through you, I'm wondering if the chairman can tell me what is an other?
Senator Winfield.
I don't know what the question is. Where are you in the bill? I would ask.
Senator Sampson.
Through you, Mr. President, I honestly don't know if the term other is used in the bill, but it is the thing that is intended to be banned by the bill that is before us. And actually, thanks to some crack staff at 3 in the morning, plus, I do find it in the bill. It's on line 1421, where it says, any semi-automatic firearm other than a pistol, revolver, rifle, or shotgun, and so on.
Senator Winfield.
So the issue really is that an other is a type of firearm that doesn't fall into those other categories. It is somewhere between a pistol and a rifle. And back in 2013, when the legislature passed the law banning, at that time, their category of assault weapons, they omitted those firearms. And today, this bill proposes to capture them. And no doubt, what will happen in the future is that people in the firearm industry will again have to adapt to whatever policy is passed today and develop some other type of firearm that is probably technologically deficient as a result of these restrictions, but they'll do so, and we will be back again to ban another whole class of firearms. And I didn't mean to get too far off track, but I'm trying to make the point that over the decades, we've passed numerous laws categorized as assault weapons ban, and every one of them was all designed to simply capture more guns to ban based on nothing more than cosmetic features. I just described it. You know, it's a flash suppressor. It has a pistol grip. It has a arm brace. Those things don't matter. They don't make guns more dangerous. They just make them into a category that you can ban. And again, this section fails on the same questions as others. Will this save lives? I don't think so. Is it worth violating the rights of our constituents to do this? I don't think so. And does it meet the requirements laid out in the Supreme Court case, New York State versus Bruin? No, it doesn't. In fact, the firearms that are listed here are in the most common use. I had mentioned earlier that that was one of the requirements. Things that are in the most common use cannot be banned because they are accepted as historically traditional. I do have a concern in this section that has to do with the ability of someone who owns one of these firearms to pass it on, much like we talked earlier about ghost guns. It seems like the bill that's before us basically leaves you very few options. If you own one of these firearms and you want to sell it, you basically cannot. You can turn it back into the state. You may be able to sell it back to a gun store, but if they can't sell it to anybody, I doubt they're going to want to buy it. And yet the bill does not allow anyone to transfer one of these firearms to another person who is lawfully able to possess it, which seems to make no sense. Since it's already in existence, and if somebody meets the qualifications to own it, why wouldn't another person? And there are certainly circumstances where people need to pass on their firearms to a family member, things like that. So, Mr. President, through you, I have an amendment. It's LCO 9573. I ask the clerk to call this amendment, and I be given the opportunity to summarize.
Mr. Clerk.
LCO 9573, Senate Amendment M.
Senator Sampson.
Thank you very much, Mr. President. This is a very straightforward amendment, and effectively all it does is it allows someone to transfer a assault weapon under the bill to any member of such person's family who is not prohibited from owning a firearm. And I move adoption. I'd like a roll call vote.
The question is on adoption. Would anyone like to comment on the amendment? Would anybody like to comment on the amendment? Seeing not, I will open the machine. Mr. Clerk, can you please call the roll?
Immediate roll call vote has been ordered in the Senate. We're voting on Senate Amendment M, House Bill number 6667, an act addressing gun violence. Immediate roll call vote in the Senate.
Amendment M to HB 6667, total voting 34, total yay 12, total nay 22, absent 2.
Amendment fails. Senator Sampson.
Thank you very much, Mr. President. I'm going to move on from the assault weapon sections of the bill, but there's one other thing that I failed to mention about the assault weapon ban that is contained in the bill that's before us, which is that the firearms that are being added to this category fall into that category of quote-unquote others, firearms that fall between a pistol and a rifle. And they are a very significant portion of the firearms sold in Connecticut currently. I've had firearm dealers indicate to me that they may be as much as 25 or 30% of their total sales. And it makes me wonder whether or not any of this is motivated by the notion that we can damage the entire industry of firearm sales in the state of Connecticut. And we are not supposed to talk about intent in this chamber, and I don't mean to cross that line. But I will say that I know that people that are in that industry are very concerned. I've talked to several firearm dealers who are terrified that this is going to put their operations out of business. And that would be unfortunate. That would be unfortunate not just for them, but for consumers and our constituents that we represent, who have the natural and fundamental right to exercise their Second Amendment and to purchase a firearm. And we should not be altering policy in a way that prevents that lawful activity. And we certainly shouldn't be doing it unless we can make some sort of strong argument that somehow it's going to have an effect. And I'm confident that I've illustrated to a very, very strong degree of satisfaction that this bill just doesn't do that. The items that are being addressed in the language before us are not activities that harm people. They are all victimless crimes, as I mentioned. There's a couple more sections I want to talk about in the bill, also victimless crimes. Section 27, this changes the penalty for the possession of a magazine that holds more than 10 rounds. This is, forgive me, maybe one of the most idiotic pieces of legislation ever written, in my opinion. The idea that somehow banning the possession of magazines that have a higher capacity is going to limit the amount of crime that occurs is absurd. Can you imagine, considering that most firearms, most handguns today, are sold with magazines that are far more than 10 rounds, of course, unless they are in Connecticut, where they are required to be limited. But before that limitation existed, hundreds of thousands, I don't know the exact number, of those firearms were sold in Connecticut with magazines more than 10 rounds. So many of them were required to be registered as a result of the bill passed in 1993. But just let me throw this out for you for the sake of argument. Can you imagine a criminal, someone who's intent on committing a crime? Let's say there's someone, he wants to rob a liquor store, and he's sitting in his car outside before committing this crime. And he's got his firearm, he's going to go into the store and do a stick-up. Do we really believe that that guy cares that the law says you can only have 10 bullets in your gun? Do we really believe that? That's ridiculous. That guy is going to put all 17 rounds in there because he's a criminal. But you know who's only going to have 10 rounds? The guy who's going to have 10 rounds is the guy who follows the law, who registered his magazines, who's doing the right thing, who's in his house some night at 3 in the morning when some people break in. Maybe there's 3 of them. Maybe they're armed with God knows what. And this poor guy is going to have his gun with 10 rounds. And I'm repeating this story much like my dear friend who's passed on, Al Adonolfi, described it. He said, if it was me, I'd probably put 3 in the floor and 3 in the ceiling before I ever got anywhere near my target. And that's what's going on here, folks. We are telling the people who are law-abiding, decent members of our society that they must limit their ability to protect themselves because of laws that are arbitrary that only are going to affect them. Criminals don't care about magazine restrictions. People that are going to commit terrible atrocities don't care about these types of laws. They can drive over state lines and get the firearm that they want. Only law-abiding citizens are going to be affected by these policies. And the result of that is more crime, more violence, more deaths, not less. The last section I'll mention as a negative section, because the final sections of the bill, as was mentioned, 36 through 48, are sections that came to us from the big city mayors, more or less. And while I don't love everything that's in those sections, much of it are positive steps towards actually fighting crime and recognizing that the issue is not guns, but criminals who use guns. But the final bad section of the bill that I would mention is Section 35, which bans the purchase of body armor. Through you, Mr. President, how does restricting the purchase of body armor prevent gun violence? Through you.
Senator Winfield.
Thank you, Mr. President. I believe that the discussion around that was to restrict body armor in certain ways as it's suggested. And we've seen some crimes across the country, actually, where the police had a difficult time dealing with the perpetrator because of the body armor that they had. And I believe this section is attempting to get at that and restrict it to those who might have an official duty or something like that, as opposed to just generally having body armor out there.
Senator Sampson.
Thank you, Mr. President. I can certainly appreciate that answer, but let me ask this. Can you purchase body armor in another state? Through you.
Senator Winfield.
That may be the case. Through you, Mr. President.
Senator Sampson.
Thank you very much, Mr. President. I venture to guess you can buy body armor in most states. And I would say most people that are purchasing body armor are doing it for defensive purposes. But even if there was the isolated example where someone who wanted to commit a vicious attack on something and thought that they would arm themselves with body armor, first, this law is not going to stop them. Anybody who is willing to go to those lengths is certainly willing to go across a state line to get it. And we have the net effect of limiting the free citizens of Connecticut from being able to purchase something that might protect them. I don't know if people listening realize that, they make backpacks for kids that are made out of body armor. They make bulletproof sweatshirts, in fact, for children. Through you, Mr. President, would this Section 35 ban those items for sale in Connecticut as well?
Senator Winfield.
Thank you, Mr. President. The definition for that section is in lines 2351 through 2354. And when it refers to body armor, it's talking about, as was suggested, to provide that penetrative resistance and to be worn on or under clothing on the body, like a vest or other article of clothing. That does not describe, to my mind, the type of armor that might be in a book bag of a young person, unfortunately, given the development of guns in this country.
Senator Sampson.
Thank you, Mr. President. And I was having difficulty hearing the good chairman. Did he say that it would or would not include a book bag or a backpack? Through you?
Senator Winfield.
A book bag is not worn like a vest or article of clothing, so to my mind, and it's not worn under one's clothing, although some kids once in a while do that, but it's not generally worn that way. I don't believe that the book bag would qualify there. Through you, Mr. President.
Senator Sampson.
Thank you, Mr. President. And I certainly hope that the people in the future are taking into consideration this legislative intent conversation, because I don't read it that way, but I'm happy to. It says, as used in this section, body armor means any item designed to provide bullet penetration resistance and to be worn on or under clothing on the body. It does say like a vest or other article of clothing. It might be argued that a book bag is not an article of clothing, but it is certainly worn on the body. And there are other items for children. As I mentioned, they have bulletproof sweatshirts that are offered to parents for use with their kids. And this effectively prevents that from happening. That's all I'm going to say about the bill, Mr. President. And I don't know that I really have any wrap-up conversation, because throughout this discussion over the language of the bill, I think I've covered pretty much everything that I wanted to say. I've illustrated effectively that each section of this bill fails the tests necessary for us to consider it to be good policy. I don't believe that any of these sections will be effective at preventing gun violence. I don't believe they pass our constitutional tests. I don't believe that they benefit of any such protections outweighs the rights that are being diminished by this legislation. We've established that the real problem that we have in Connecticut is not proliferation of firearms, but rather crime. Crime is out of control. And the more lawless our society gets, the more violence we're going to have. And I think the last thing we want to do is disarm the innocent people in our population. It seems absurd to me that as we have more crime and more violence and the murder rate goes up, we're going to restrict decent, honest, law-abiding people from being able to protect themselves, to say that you can't get to your firearm in the middle of the night, to say that you can't purchase certain types of firearms, to say that you can't have a certain amount of bullets in your firearm. Criminals don't care about any of these things, but they are all restrictions on people that need those things to protect themselves. The people that we represent and swore an oath to protect that right. As I said earlier, Mr. President, I will never vote to take away the rights of my constituents, even if they ask me to. And I'm a no on this bill. Thank you.